And it stands to reason as a matter of logicality. If you are doing it, you know about it. But there is also another form of knowledge, which is knowledge that the others are doing it. But that we say the criticism against the pleading is an unfair criticism. Firstly, Justice Rogers has pointed to paragraph 185 of the pleading. And that paragraph is actually important, particularly paragraph 185.3, which is at page 429, because it says one of the strategies that were used by the traders was to inform competing traders when engaged in posting fake bids or offers. So they were not just coordinating without informing the others. That's number one. But number two, there is a factor that has not yet been taken into account, which is what is pleaded under the effects section, particularly at paragraph 275 to 279, page 465 to 466. What those allegations say is that the traders knew the effects of their conduct. And they knew the effects of their conduct. If you look at 275 in the last sentence, the traders were aware of this when they engaged in the collusive conduct and posted codes, or in some cases withheld codes on international trading platforms with the aim of manipulating the rand and dollar exchange rate and moving the market in a desired outcome. If you turn over the page to 466, 278, it is also alleged the traders could see in real time the effect of their manipulation on the currency exchange and the lasting impact on the bid and ask spread. So I ask rhetorically, if they knew the consequences, how could they not know that others were doing it? So if those are the ground rules of pleading an SOC, we have three banks that I want to just deal with separately. Three traders rather, Cook, Katz, and Hattin, because they fall in the same category. These are the members of the old GITS. These are the most prolific participants, and these are in relation to other banks where it has been found that they are part and parcel of the SOC. But they have been excluded from the SOC by the CAC on very flimsy justification. First, it was held that an employment of a trader by a bank is not the only basis to implicate a bank in an SOC, which is clearly wrong, because the allegation that we've made is that a person who is duly authorized suffices. Second, it was held that membership of a chat room isn't enough to attribute knowledge of the SOC, which is also clearly wrong. And lastly, it was held that Cook should have been linked to an actual bank, which is also legally wrong. The same applies to Hattin, who was with HBUS, the 19th respondent. The same applies to Standard Americas. They employed Katz for 10 years, and he traded on their behalf. 10 years. And I stand corrected, of course, by Ms. Engelbrecht. He did not serve time in prison. He served jail time at home. But these banks, on any credible version, are in the SOC. They employ the masterminds of the SOC. That is Bank of America respondents, Standard Americas, and HBUS. And if you accept the analytical framework that we suggested, which is first work out who is inside, and then work out who can be excluded on other grounds, then there can be no debate that the Bank of America respondents, Standard Americas, HBUS are all in the SOC. So this debate today and yesterday and the day before was really about whether they should be excluded, because the facts are overwhelmingly suggestive of their regular participation in the SOC. But they cannot be excluded because on jurisdiction, the CAC simply got the law wrong. I will deal with jurisdiction later. Let me continue with two other categories. The second category is traders that are not in the old GITS, that are not in the ZAR. And there, two objections have been taken. The first is the interpretation of the charts, that perhaps the charts were benign. And the other is that the charts perhaps are too few to infer knowledge of the SOC participation. But as Mr. Wilson for Macquarie said, the number of times is not decisive. It is the nature of the discussion that may be important. But we have additional factors here. One, the conversation is collusive. Two, its effect is to increase market transparency. Three, the counterparty is a regular player. And this is a crucial point. Why are they talking to Katz about bid-offer spreads? Why are they talking to Williams about bid-offer spreads? Why are they talking to Ayer about bid-offer spreads? These have been referred to here as the rogue traders. So one participation with a rogue trader is enough to bring you in. We ask the court to have regard to page 12084 to 12085. Those are the documents that were used by the tribunal and the CAC to fully explain the nature of the interaction. The first document is conversations, the second is trading data, and the third combines conversations and trading data. When you look at that picture, it becomes impossible to see this as isolated instances of unrelated conversations. And then the last category is the pure trading data. Our submission here is that as a matter of law, it is permissible to use samples to illustrate economic patterns. So do not get diverted from the real job by hearing that it's only 6 instances, it's only 9 instances, it's only 11 instances. These are illustrative examples to illustrate patterns. They ask, where do they come from? One can infer, because I can't give evidence from the bar, apparently, according to Ms. Engelbrecht, but one can infer that most of the evidence that the Commission has comes from the leniency applicants. And so we say that economic data, we can draw illustrative examples there. That is the law in Europe. And I hear what Mr. Wesley is saying when he says that this trading data perhaps shows that there could have been a local cartel, rather than a big cartel. Well, we don't know. The evidence will show us. But the correct legal question is that on the pleadings, the only reasonable inference that you can draw is that they were not acting separately, but they were acting together. This much is fully explained by the tribunal at paragraphs 131 to 143 of its ruling. It's actually a compelling part of their findings. So I leave it at that. The truth is, all the 3 categories are in the SOC. They were there, Deputy Chief Justice. They did it. The second theme is around jurisdiction. We argued that Section 3.1 of the Act has extraterritorial application, and it is therefore decoupled by the legislature, not by me. It is decoupled from the common law requirement of personal jurisdiction. Or alternatively, the impact of Section 3.1 has been to substantially attenuate the grip of the common law. What you have heard is a spirited defense of the common law. One of the advocates even said, how could you jettison 300 years of the common law? Well, the legislature has done it for us. The judges don't need to do it. They just need to give effect to the legislative intent. And here, Mr. Turner, I know, has argued something unique, that the trade must come from the Johannesburg branch. He relied on a judgment of the Eastern Cape Local Division called Appleby versus Dundas. But it's actually irrelevant, Justice Majid, completely irrelevant, because it was not setting the common law. It was interpreting Section 5 of the Administration of Justice Act of 1912. 1912. And it was interpreting a specific word, reside. Not only has that act been repealed twice, It has nothing to do with the Competition Act, because the Competition Act has unique jurisdictional provisions. How the CAC thought that judgment was relevant completely defeats me. But we also argued, more importantly, about 4 connecting factors. Whatever we say about res judicata, whatever the debate on that topic is, and wherever it ends, there is something undisputable. These 4 connecting factors that were found by the tribunal, and no one could actually dispute them. 1, the rand, the symbol of our sovereignty. 2, the fact that in the conspiracy there are firms that are based in South Africa, including Absa and Standard Bank, and Investec. 3, the fact that there is no other jurisdiction that is prosecuting the rand manipulation. And 4, the fact that the allegations are that the banks violated South African laws. No one could contend with those connecting factors as the decisive factors that bring the entirety of the SOC within the reach of the South African authorities. The third theme is that we argued that this case bears the hallmarks of an international cartel that cannot be effectively prosecuted, A, without an SOC doctrine, and B, without extraterritorial powers. We argued that the consequence of the approach taken by the banks, and they did it in some instances with a lot of vigor as to jurisdiction, is actually to promote and encourage impunity. It is to defang the only jurisdiction in the world with the closest connection to the suit. And there could be no debate about that. The fourth theme is that we argued that in relation to exceptions, new evidence is not allowed. Parties should be confined to the pleadings of the Commission. If a party elects to bring a dismissal application, it is not allowed to bring in new facts under the guise of a dismissal application. Standard Bank is separate. I'll deal with them last. And the fifth theme is that despite the many arguments that the Commission had no jurisdiction to refer the dispute because it had not properly initiated against certain parties, we showed that there is no finding, and this is crucial to the entire conversation about initiation. There is no finding by the CAC that because there is no valid initiation, there was no jurisdiction to refer the dispute to the tribunal. Initiation, yes, is discussed at paragraph 145 of the CAC judgment, but it is not followed by any finding. So there is no decision on initiation that is capable of a review or a reconsideration by this court. There is no decision at all. There is no appeal against reasons. There is only appeal against outcomes, orders. Instead, if you look at paragraph 184 of the judgment of the CAC, it is made abundantly clear that the problem was that the joinder violated the order of 2020. That is the finding. In fact, it is under the heading, the findings. It's one of the things that have been done correctly in that judgment. So the only thing, therefore, that is before this court is whether or not it is correct that these parties that were joined after 2020 were joined in violation of the court order. Initiation is irrelevant to the debate in this appeal. And this is a crucial distinction because it renders the debate on the competency of the referral a moot one in the absence of a finding that strikes out the referral in relation to the affected parties. And there are only 2 questions that are relevant to the question of joinder as decided by the CAC. The one is whether the order of 2020 prohibited the application by the Commission to join new parties. Ms. Sigalala, my colleague, has done a careful analysis to show that in no way could that judgment and order be read to take away powers of joinder, given that the tribunal sources its powers in the Act and in the rules. She relied on this court's judgment in SOS versus SABC. A further factor, which is crucial, is that when it comes to joinder, since the tribunal is exercising a discretion, appellate interference is circumscribed, and there is no justification in the judgment of the CAC on the standard rules for interfering with discretionary decisions, why they interfered with the exercise of that power by the tribunal. Those are the 5 core themes which have not been disturbed, despite the multiplicity of the arguments. In substance, they never disturbed those 5 themes. I want to address then some outliers. First is ANZ. The issue about ANZ, I know Mr. Loxton is going on about misrepresentation. There was a lot of this term misrepresentation in this case. So I'm not going to say he misrepresented us, but he felt, okay, well, misrepresentation is a nice word. But this is the point made about ANZ, 2 points. The first one is that Aya cut and pasted a conversation in a chat room that involved Tezel. Now, Aya could not have access to a chat room unless he was a member of the chat room. There are only 2 other traders there, is Tezel and Madras. That is Citibank and then Aya. Aya, we know, is one of the rogue traders. Not because of what I am saying. If you look at the referral, Aya comes in towards the end, page 470, where it is stated in 295, the United States Department of Justice laid criminal charges against Cummins, Katz, and Aya in respect of their participation in the conspiracy. 297, in November 2019, Aya was found guilty in the New York Southern District Court of the charge of knowingly entering into, participating in a combination and conspiracy to suppress and eliminate competition by fixing prices of and rigging bids of offers for Central and Eastern European, Middle Eastern, and African, which is where we are, emerging market currencies. So what we have, which is most extraordinary with Tezel, is that he is in a chat room with Madras and Aya. It's one that is true, but look at the counterparty. It's Aya. The man is a criminal. He must go and answer for himself, Tezel, why he was engaging with a criminal. So there is no misrepresentation here. This is a correct rendition of that pleading. The second connection is Katz. Katz is also a criminal. The allegation, the statement that has been made against us on Katz is that no, it is unfair because the last conduct of Katz is October 2012. He comes to be employed by us in 2013. And then they say you are drawing an inference based on the absence of evidence. Nothing could be further from the truth. Why we say the correct inference must be that Katz probably continued when he joined ANZ, or at the very least, ANZ must go and explain. Katz was prolific, at least for 6 years prior to joining ANZ. We also know Katz's conduct before. Every time you change an employer, he picked up from where he left. Standard Americas, 2001 to 2010, where he again was involved in currency manipulation. Barclays, 2010, he was involved in currency manipulation there. BNP, 2010 to 2012, he was involved in currency manipulation. What inference can you draw that when he joined ANZ, he will suddenly change his ways? It is an impossible inference. You are being asked to do something that is just impossible in logic. But that inference can also be supported by the pleadings. The referral says it is most probable that the conspiracy continued to operate after September 2013 using different modes of communication if they closed the implicated chat rooms. You will find this at paragraph 278, page 466. The Commission also alleges that each of the respondents continued as participant until such time as they expressly dissociated themselves with the conduct. terms and objectives of the SOC. And this was so regardless of whether the trader ceased to be employed by a particular respondent. In competition law, particularly in cartel cases, it is perfectly acceptable to take the view that if you once participated in misconduct of the kind that is covered in Section 41B, you bear the onus to distance yourself from it publicly. So for as long as you have not publicly distanced yourself from it, it is perfectly legitimate for competition authorities to draw the inference that you continued with your conduct. You'll find the allegations at paragraph 70 and 71, page 405. The referral also alleges that the respondents knew or ought to have known that their employees were engaged in conduct that implemented the terms or furthered the objectives of the conspiracy, or that their employees or respondents were aware of such conduct. That you will find at paragraph 66, page 401. So then back to Tezo. He is in that chat room. That's the only way in which Aya can cut and paste conversation from a different chat room. He is with Madras, Citibank. He is also with Aya, a criminal. Katz has joined them. He's a criminal. Those are sufficient to establish an inference that ANZ is correctly cited as a participant to the SOC. There is, of course, the challenge brought in relation to some that say it's one or two instances, but we have addressed that. You have to look at the nature of the conversation and look at the counterparty. There is Standard Americas, which raises a different point, and I've shown that Standard Americas on any version of these pleadings is inside the SOC. They want to be out of it. What do they say? They say that the Commission has willfully sat on its laps and done nothing since the 23rd of March 2017. This requires some context. The first referral was made on the 15th of February 2017. And it was amended on the 20th of December 2017. There were exceptions taken, and let me explain this. The primary exception was that there is no jurisdiction against a Peregrini, full stop. That was in CT1, the first time we went to the tribunal. Those exceptions were set down on the 30th of July 2018. They were all upheld. It was found that the tribunal has no jurisdiction over a pure Peregrini. Now think about this, justices, just the common sense of it. The Commission is being told here that it should have joined Standard Americas, a pure Peregrini, despite the pending exception that pure Peregrinis cannot be joined, despite the finding by the tribunal that pure Peregrinis cannot be joined. The judgment was given a year later, 12th of June 2019, upholding all of the exceptions. Then the matter goes to the CAC. It gives the judgment 8 months later, 28 June 2020. Again, we have a year and a half of the tribunal proceedings. We have another 8 months of the CAC proceedings. Ms. Engelbrecht says, join us. What is the logic in this? Is this a serious argument? Then, the first time there is an opportunity to join Standard Americas is when a new referral is to be made. Why? Because the law has been changed to allow the Commission to join pure Peregrini. So if you want to tell the story, tell it in full. And that is why it's not surprising that they appear for the first time on the 1st of June 2020. It is correct, they did say that they don't employ him, but the fundamental problem was that the case at that stage was that no Pio Peregrini should be joined in the case. Then there is a Standard Bank situation. I need to just spend some time on this because it may appear to have been overlooked, but it has not been overlooked. They say, and this is the only party that raises the argument, every other party accepts that in exceptions, no new facts are allowed. Standard Bank says you should allow new facts on exception because of what they refer to as fairness. Let me answer this firstly as a matter of law. The introduction of the standard of fairness as a basis for the introduction of new evidence destroys the essence of an exception. An exception is to weed out a bad claim. Before trial, you weed out a bad claim. That's the point of an exception. Once you introduce new facts, you destroy the basis of an exception. However, the reason why the idea of fairness is nonsensical here is because if you want to advance your own story, you are not without options, because you can take a special plea, but you have an obligation to plea over. Or you can take an in limine defense, but you must plead over. In either of those instances, a special plea or an in limine defense, you can raise any new facts. So there is no need for this court to destroy exceptions in order to allow Mr. Sintin or allow Mr. Brownrigg to tell their story, because they are accommodated on the existing legal instruments. The only problem is they didn't want to take them because they never wanted to tell their story. But it is also an impossible test to apply in practice. Think about it. Currently, the tribunal is stuck with this case that has been running for 10 years because at every stage it's met with a procedural objection after another. Every party will say, sorry, it is unfair in my case to be asked to plead over. I want a chance as well to just give you cherry-picked facts. So it will be impossible and therefore unfair to the administration of justice. Because fairness cuts both ways. It must be fair to the public as well. The Competition Commission represents the public. But let us also look closely at what Standard Bank has done. Standard Bank has been the most aggressive litigant in this trial that we are dealing with here. It's been the most aggressive of all of the banks. It has taken every procedural point right up to this court. You remember what happened, Justices, in 2020, when you delivered a majority judgment dismissing the appeal of granting the appeal of the Commission in relation to whether or not Standard Bank was entitled to the record. It was the record in this case. What did you say? Paragraph 128. It must further be underscored that the complaint and by extension the litigation procedure employed by the competition authorities have been subjected to protracted legal challenges. Who subjected us to the protracted legal challenges? The bank today that pretends to be innocent. Recognizing this, the Competition Appeal Court in Sandhurst likened the acts of attempting to avoid and evade responsibility to the Stalingrad method of litigation. This was further echoed by the Supreme Court of Appeal in Woodlands, where it stated that a veritable forest of interlocutory paper is generated in order to prevent cartel disputes from being determined on their merits. A legion of cases is not adjudicated on the merits due to these prolonged procedural challenges. The prolonged challenges are made possible due to the extensive resources often available to respondents in competition matters. The Competition Commission simply does not have the money of Standard Bank. And the secretive, at times almost untraceable, nature of the prohibited practices that the Competition Act aims to regulate. These considerations challenge the notion that the Commission is an omnipotent state organ that employs unfettered powers and attacks defenseless and resource-constrained individuals. The courts have to be alive to the reality that the Commission is engrossed in complex legal and economic challenges against well-resourced, powerful entities. That was the case of Competition Commission versus Standard Bank, reported already in 2020. Now, Deputy Chief Justice, the term Stalingrad is the highest form of censure to any litigant because it is an opprobrium by this court that such a litigant is frustrating the proper administration of justice. Unfortunately, Standard Bank learned nothing from that case. Moreover, Standard Bank's affidavits that it now claims should have been admitted in the interest of fairness are deeply problematic and cannot be accepted without more. Since they were heavily relied upon, it is necessary to analyze them. Firstly, Standard Bank says it has investigated the matter, but it never tells us what it found in the investigation. All it tells us is that it found that the two allegations in the referral are unfounded. But no doubt the first thing they would have done is give us the entire chat between you and Taylor. And if it was playing open cards, give us that chat to the Commission. Never does so. Selective use of evidence. Secondly, the affidavits are carefully drafted and carefully framed. For example, they say that Brownrigg is not a trader authorized to trade. But was he trading? Who were the names of the traders that Standard Bank employed? They never tell us. They know the names of the traders. If they say you've got the wrong guy, who is the right guy? Then, when you look at Brownrigg's affidavit, particularly at page 1875, he denies the conversation with Taylor was collusive. But here is an important factor. Taylor, and that's the most important thing in a Qatar, Taylor never submits an affidavit. Taylor never submits an affidavit. What happens to Taylor? Sintin says, I wrote an email to Taylor asking him to confirm certain allegations. Taylor never sent an email in response. Never sent an email. Instead, according to Sintin, Taylor called him. And what we then have is a version of Sintin of those conversations. They have access to Taylor. Why are they not giving us Taylor's affidavit? So you have a one-sided version with no corroboration from an accused cartelist. It would be an irresponsible competition commission to accept that without more. Brownrigg does not deny the knowledge and the use of chat rooms by traders and other employees. And as I say, if he says he has investigated it, where are the chat rooms? What do they say? We were told yesterday that the affidavit says that the markets were closed on New Year's Day. Were closed on New Year's Day. But, Justices, I want to request that you look carefully at the affidavits of Standard Bank, because in my respectful interpretation, they never say the markets were closed. They hedge. They hedge first by claiming at paragraph 7.2.2.4 that the only reasonable inference that they can make is that the trade happened during the night when the SA Forex market would have been closed. That's the first thing. They say, it happens at night, we assume that they must have closed. Number two, paragraph 55.1.4, they say the most likely explanation for this conduct, if it did occur, is that the information platform was switched off, which is now different thing to the closure of the markets, was switched off and switched on shortly after 7 a.m. and on 2 July 2008. And then they say, I am forced to speculate because the Commission won't give us data sets. You remember what the European authorities said? They say, you have the data sets yourself. And they continue with this trend, would have, could have. Paragraph 55.25, the trading desks would have been closed. Paragraph 55.5, 55.45, would have been closed. Paragraph 55.11.3, even the after-hours desk established in October 2011 would have been closed. Paragraph 67 would have been closed. Never committing to a version is a careful way of constructing an affidavit. When you read the 3 affidavits that have been submitted by Sinton and Brownrigg, what you find there is a lengthy criticism of the Commission's case. You never actually find a positive version from Standard Bank. Now ask yourself the question, why on earth would the Competition Commission say, in fairness, let us just accept everything they've said and then withdraw the case against them? It amounts to saying, I'm not guilty of collusion. I've told you I'm not guilty of collusion. Now withdraw the case against me. It would be a grossly irresponsible commission to adopt that approach. So we therefore say, even on the outlying cases, when you actually interrogate the true facts, you cannot find fault with what the Competition Commission has done. In those circumstances, Deputy Chief Justice, we ask that you uphold the appeal and that you direct the parties that are yet to plead to do so without delay. Thank you.
Sorry. There was extensive discussion by this bench and Ms. Zigalala, and I think the other banks latched onto this discussion about the reliance on the Pickfords. You haven't told us anything about that.
Because I say Pickfords is irrelevant, I agree with Justice Majid.
Yes.
But it's not irrelevant for the reasons that he proposes.
Yes.
It's irrelevant because this judgment was not decided on initiation. If you go to paragraph 184, that's the basis of the decision, 184, page 296 at volume 3. So it's under the heading, the finding. 184, the tribunal's finding that the referral affidavit, which was placed before the court when it made its 2020 order, could be reconfigured to pass legal master, could include further banks subsequent to the initial referral, must be set aside. That means Nedbank, First Rand, Standard Americas, which were cited in June 2020, were improperly joined. The application to set aside the joinder must succeed. There is an error there because there is one bank, I think it's First Rand, that actually never applied to set aside the joinder, but the judge somehow thought that they had.
Thank you, Advocate Ngagitobi. I'm sure my colleagues have got questions for you.
May I follow up on that one? Do you read 184 to say actually, can you try and explain, can you explain to me what that means, that first sentence, 184?
It says the finding, the tribunal's
English,
finding...
my English is not good enough to understand that.
I think yours is probably better than mine, but let's see if we can help each other. The tribunal's finding that the referral affidavit, which was placed before the court when it made its 2020 order, could be reconfigured to pass legal master, could include further banks to the initial referral to the tribunal, must be set aside. I mean, I think, look, it's bad grammar, but what they're saying here is the tribunal's decision to allow a joinder must be set aside because the 2020 order did not allow the inclusion of further banks.
Well, I understand what they say, but what is the reasoning? What is the reason? What is the ratio decidendi here in this sentence? And you say,
It is
if I
discussed.
understand it correctly, you say it is because the 2020 order did not allow you to do that. Is that what it means?
Yes, that's what it is saying. Yes, that's the ratio. In fact, Justice Majid, if I could just complete, I'm sorry, I know you're talking and I spoke over you.
Sorry, I thought you finished. I'm going to move to something else.
No, I was just going to say, could you add page 242, paragraph 37? So that would be the ratio, and then that's the finding.
Now I see it. Okay, thank you. Can I ask you about res judicata? A lot of time was spent on it yesterday. Now, just hypothetically, if we come to the conclusion, and it's if, I say if, that the matter is res judicata, does this court have any basis on which to move to a point where we say, well, this is in the interest of justice to hear the matter anyway because it's res judicata? Because I'll tell you why I ask. I think it was Mr. Cockrell who made a very important point, and I think he's correct on the face of it, that res judicata is an essential component of the rule of law. Would we be able to go that far to say it's in the interest of justice, notwithstanding that res judicata finding to consider the matter?
Yes, in fact, I think it was in Mr. Cockrell's argument where I think it struck me that there is a conflation of two concepts. The one is the correctness of the 2020 order and whether or not you are bound by it. Now, on Mozilla, you are not bound by it. You can correct it. So if you're correcting it because it's legally wrong, you can correct the judgment. There is a separate issue about res judicata, which is whether it's binding, despite its legal imperfections or legal flaws, whether it's binding on the...
Before we go to the second one, I'm sorry to interrupt you, just on Mozilla. You see, in Mozilla, we dealt with a case before us, but it came very clear unanimously to all of us that Guarnieri was wrongly decided. And obviously one of the parties, I think it was the pension fund, the pension adjudicator, relied heavily on that judgment of the SCA. And in the course of that, we came to the conclusion that we had to make a pertinent finding that that case was wrongly decided. But what the banks argue here is that you can't then say as an applicant, well, because you had set aside a judgment in the course of deciding a case, an SCA judgment, you can now help us in this res judicata argument. They say you can't go that far. Mozilla isn't authority for that.
Yes, I understand that, and that's probably why I'm trying to draw a distinction between whether you are entitled to correct a wrong decision that is not on appeal. Mozilla is authority that you can correct a wrong decision even if it's not on appeal. So that would apply equally with the 2020 order. You can correct it even if it's not on appeal. That seems then, and again I'm drawing from the analysis of Mr. Cochrane, to leave out the question of res judicata, which is a separate issue altogether. And that is whether or not the Commission is nevertheless bound by the wrong judgment of 2020. And that is where res judicata operates. It doesn't operate to bar this court from correcting a wrong judgment. The problem here is that where the interests of justice fit in, it would be an artificial outcome, especially because of where we are in the trial. We are at the beginning of the trial, right at the beginning. It would be an artificial outcome to deprive the Commission of the benefits of the correction of the 2020 judgment, because there is no prejudice to that at all. And so it would be in the interest of justice in this unique case to then relax the consequences of res judicata if you have corrected the incorrect judgment based on Mozilla.
The last one on a different topic is Section 3.1.
Yes.
If we uphold your primary argument on Section 3.1, there are some of the banks that argue very vigorously, they argued that that would give you, as I understand it, and they'll forgive me if I overstate their submission, they say that that will give you extraordinary wide jurisdiction. And the suggestion, as I understand it, and again I may have misunderstood it, the suggestion is that it is it's unique in the world to have that kind of extraterritorial jurisdiction. Now I speak as one with little experience in competition law. Is that a sound submission to make?
Certainly not in competition law. I think for the reasons that Justice Rogers pointed out, basically the reasons of comity, which in fact is probably the most useful lens through which to look at personal jurisdiction, especially because of the interconnected nature of the economies. I know that in the last 3 days we've been talking about cartels, but you can expand the framework of imagination to include Section 8, abuse of dominance cases, Facebook, Google, that are all operating in all markets, but located in the tax havens of Jersey. But the impact of their decisions is actually significant in all markets. And look at the approaches that have been taken in Europe and in America, where they have exercised extraterritorial power in order to prevent economic abuse and sometimes abuse of dominance. So once you take an unduly restrictive approach to jurisdiction in relation to cartels, you must remember that it will permeate across the entire scope of the Act. So I'm afraid to say it's actually an unsound approach to take in competition cases.
Thank you, Mr. Nukatobi. Thank you, GCJ.
Mr. Nukatobi, still on the question of Pickfords and initiation. One or two of the respondent banks complained about the fact that they were added at a later stage and they were never afforded. There was no initiation stage, no investigation. They found themselves being added in the 2020 referral. And that's the complaint that ordinarily there are 3 stages. You started with initiation, you go to investigation, then the referral. I know Ms. Kalala said the initiation was, insofar as conduct, the prohibited conduct was concerned. But they are saying over and above that, the firms should have been, something should have been done. What is your response to that?
Yes, Justice Mhlantla, this is an academic discussion in the context of this case because it has no bearing at all. There is a discussion at paragraph 145 of the judgment, but it is a discussion with no end, no conclusion, no finding. When you are trying to work out what was the basis on which these banks were excluded, was it initiation or was it the breach of the 2020 order? That is decisively answered by paragraph 37 and 184. The reason why these banks were let off the hook, let's call it like that for lack of a better word, is because the judge found that we had violated the 2020 order. So the only debate before this court is whether it is correct that we violated that order. If we did not violate that order, then there is no issue that arises for discussion on initiation. That's the first thing. So that's why it is an interesting discussion, but it is entirely academic. When it comes to initiation, Mr. Kalala made 2 submissions. One is based on Pickford's initiate against an entire prohibited practice. The second one, which seems to have been overlooked, is tacit initiation, which comes also, Pickford's reinforces that it comes from Woodlands, which is initiation is an informal process. You don't even have to issue any document. The question is whether in April 2015, there was no tacit initiation in relation to every other participant to this cartel. And if there is one bank that can simply never complain about tacit initiation, it's Standard Americas, because the initiation was against Standard New York Securities. And if you're trying to work out what was in the mind of the commissioner when she initiated the proceedings in 2015 in order to figure out this debate about tacit initiation, it is impossible that she thought she can initiate and exclude certain banks that were in the SOC. She was initiating tacitly against those that she knew, but against everyone, even those that she didn't know.
What happens when you get information during the process of investigation, get further information that other banks or parties are implicated? What is the normal procedure? What would be done by the commission?
Yes. Well, there are two approaches to it. The one is Pickford's, which is what we dealt with here 3 years or 4 years ago, which is they just get added to the document. So you've got a long document with 25 possible respondents, you put a 26th and say, I've just found your name, you add them. But you don't now go and start a new initiation. You just add them to the existing initiation because that's the name you have found. In this particular case, the most useful thing to do was to add them to the referral because already in April 2015, you had initiated against the practice and you named those you didn't know, and then you found out others. And then the only debate is about prejudice. It's actually a height of artificiality, this idea that every time you find a new respondent, go and initiate afresh, because what it does is then you run parallel proceedings because you're already in the trial, you're already prosecuting against certain banks. You find out, actually, I was wrong, there are 3 more. According to them, start afresh and run another trial on those facts. Now, that just makes no sense, which is why the correct interpretation is that actually you would be allowed to add them at the stage of the referral, even though they are not named in the initiation, because you must take the initiation to be a tacit initiation against the participants, named and unnamed.
In Pickford, there were 2 initiations.
Yes.
The original one is 2010, where Pickford was not mentioned.
Yes.
And then when you got to know about Pickford, you had a second one in 2011.
Precisely.
So you're saying you don't necessarily have to do that all the time?
No, it would be impossible. I mean, if you have referred, so you already referred in February 2017. It's already, what you are doing now, you are amending your referral because there are exceptions. And then one of the banks settles with you. They give you their data set, including chat rooms and trading data. Say, here it is. And then they say to you, look at the following trends. That bank, NetBank, is part of us. Unfortunately, you didn't know about them at the beginning, but they are part of us. In that instance, you would be allowed to include them in the referral because your April 2015 initiation must be taken to be a tacit initiation against every participant who bears the similar characteristics of that conduct.
Some respondents, I can't recall now which one, they complained about.
You are not alone, Justice.
They were dragged in respect of one single chat or a chat that lasted a few minutes. Can you perhaps say something about that?
Yes. What is important there, we accept there are 2 banks where there is one chat. We accept that entirely. But what is crucial there is not the number of chats. It's not the number of chats. What is crucial is the nature of the information and the counterparty, to see whether it comports with the general trend of the SOC. So why are you talking to Katz about a bid of a spread? Why are you talking to Ayer about a bid of a spread? Why are you talking to Cummins about a bid of a spread? Why are you talking to Williams? Why are you talking to Howes? These are the kingpins. These are the criminals. These are the kingpins. So once you have that, it's sufficient to connect you to the broader SOC. The other theoretical postulation that we saw here is that what about the theoretical possibility that it's small cartels elsewhere? But that was roundly rejected by the tribunal as a possibility. Then the other one is, what about bilateral conversations? These are all impossibles because it's clear that there is a trading happening at a central level, and it's 2 currencies. And in order for the strategies to work according to the referral, in order for the strategies to work, for the profits to be made, it needs a multilateral character. So you can dismiss all of those as fanciful at this stage. and not supported by the referral.
DCJ.
Mr. Ngugaitobi?
Yes.
Can you elaborate on the kind of powers and discretion that the tribunal has? And if I'm wrong in saying that it has a discretion, explain to me what the powers of the tribunal are, and under what circumstances can the CAC disturb their findings. This question is in relation to the fact that in a lot of these cases, the CAC overruled the tribunal. And I'm interested to know whether it was proper or it was correct in doing so. And that will then
Yes.
be determined by what kind of discretion, if any,
Yes.
does the tribunal has.
Yes. Thank you, Justice Shirku. That's actually a very, very important question. I think most of us have overlooked. I think there are three categories of decisions that the tribunal will typically make. So there's one, legal decisions, where it's analyzing the meaning of an act. Now, we would accept there that the Competition Appeal Court is entitled to intervene and correct them if they are wrong. And that's not a discretionary issue altogether. The second is where it's evaluating facts. It's deciding on the facts. That issue is decided in the case of this court called Mediclinic, that there is a level of institutional autonomy that the tribunal exercises as an expert forum, and that's different from specialist, as an expert forum because it comprises of economists and lawyers, unlike the CAC, which is a specialist but comprises only of lawyers but no economists. So that deference to expertise has been recognized by this court in Mediclinic, that when it comes to evaluation of facts, the Competition Appeal Court will only interfere where basically they were smoking their socks. Then you have a third category, which is discretionary decisions. In that third category, you will fit there a decision as to joinder. Joinder of necessity, joinder of convenience. There, it's purely discretionary, or decisions about postponements, or decisions about condonation, etc. These are purely discretionary. You will then ask yourself whether or not the CAC has satisfied the standard rules for interference with discretionary decisions. Now, this is the problem we have here, is that basically what the CAC thought, it thought that it was the tribunal. It could redo the exercise entirely without any regard to what the tribunal said. Let's just do it the way we want. And that is very, very clear when it came to the joinder decision, because they never conducted an evaluation of the tribunal's reasoning to see whether it fits those patterns of appellate interference with discretionary decisions. So you've got two areas of constraint. One is factual evaluation, second is discretionary decision. And you've got one area of unrestrained interference, which is legal assessment.
Where you were at idiom that interests of justice have to be the determining factor. But what I'm asking is, what factors would we have to take in this matter to conclude that it is in the interests of justice to interfere?
Yes. Now, it's only if I am right in my primary submission that the CAC was wrong. If you say the CIC was right, fine, then there is no debate. But if they were wrong in CAC 2020, that is a factor that you are correcting a wrong decision. But it is also a factor that you are correcting a wrong decision in relation to jurisdiction. The second thing you will take into account is the stage at which the proceedings are at. This is right at the commencement of the proceedings. Then you will take into account prejudice. There is no prejudice in this case, and you know, I've heard a lot of things in this case. Everyone has a different rendition of what we said. Then they say, we've also distorted what we said. End up getting so confused. So on this point about lack of prejudice, you know, Justice Chief, in our pleading, I showed the court we relied on Section 3.1. We also tried to comply because we thought we must comply. Otherwise, you know, we are an organ of state. But we also relied on Section 3.1 independently from the connecting factors test. Before the CAC, we ran the argument that Section 3.1 is decoupled from the common law. We know the consequences because the transcript is here. In this court, we ran the argument again. In 2020, we had run the argument. There is no one who can be prejudiced about this argument being raised here. No one. So we would say that those three factors would play an appreciable role in your assessment of where the interests of justice lie.
Thank you, Mr. Ngugaitobi. Thank you, TCJ.
Mr. Ngugaitobi, my question relates to res judicata, which you have touched on. In relation to the third respondent, do you accept that they may be prejudiced if we reopen the interpretation of Section 3.1 in this court, since they did not oppose the application on the basis of that point being raised, the res judicata initially?
Justice Saron, no. Why would they be prejudiced? Because you are correcting the law. How can anybody be prejudiced with the correction of the law? And all of the arguments that had to be made have been made. This is one case. It's not separate cases. They want to raise their own case. But that just doesn't make sense, because why would they want to raise their own argument in addition to what others have said? What's the unique thing they were going to say? So no, I'm afraid no, I don't accept it.
Would those respondents who were joined later, the additional banks, would their position be different in relation to the previous respondents in respect of the res judicata point?
And no, they can't be. Remember that we added Incola and Standard Americas. Yes, Standard Americas and Incola. Standard Americas is here. The rest are Incola. They are irrelevant to the debate anyway.
So you say they won't be affected,
Yes.
whether they were joined later or previously by the res judicata point issue?
No, it's irrelevant to the Incola. And also irrelevant, I would say, to the two categories of foreigners with presence in South Africa, because there is another basis to exercise jurisdiction. It's only relevant to the pure peregrine, but the pure peregrine have run all of their arguments here.
And I suppose whatever decision, if the court reaches a decision on the res judicata, has to apply to all the in respect of all the respondents, whether they were joined before or later. And it shouldn't, if the court finds in favor of the respondents or some of the respondents' res judicata point, all the respondents should get the benefit of that.
Oh, no, I accept that, yes, entirely.
Yes. Thank you, Mr. Mwai.
Yes. I'm told by my learned colleague that the point was raised in the application for leave to appeal to this court, so everyone had noticed. We noticed as well that, Justice Terod, there's actually quite a lot of parties that never took res judicata. They took preemption. Once they saw that the train was moving on the res judicata, they joined in. But anyway, I'm not going to complain.
Mr. Ngugaitobi, first on the question of initiation, You say that the Competition Appeal Court only knocked out the case against the 24th to 28th respondents on the basis that the first judgment didn't allow further joinder, and therefore initiation is not before us.
Yes.
But if we take Standard Americas as an example, the actual order in CAC 2 was simply that its dismissal application is upheld, or its appeal is upheld, and its dismissal application is granted. The principle on appeal is that the successful party below, here the respondent in the appeal, Standard Americas, can defend the court below's order on any basis that could properly be raised. So that if there were 2 or 3 grounds on which it could have succeeded in the CAC, and the CAC only decided 1 ground, if that ground is wrong, Standard Americas can still say, but that order was still justified because we should have succeeded on the initiation point, which the CAC didn't consider. Isn't that the correct procedural approach?
No, that's correct, but it doesn't apply here, because I actually considered the question yesterday before raising this argument. The reason it doesn't apply is twofold. The first is that here we are not without, we are clear about what the basis for the order was. The basis for the order is set out under findings, paragraph 184. That's number one. The second thing is that an order as to initiation would have invalidated the referral. So they would have said the commission had no jurisdiction to issue the referral because it was barred from doing so because of the absence of the jurisdictional fact. That order was not made. So we are not in a stage where your referral has been set aside, but we don't know the basis on which it has been set aside, and therefore you can defend it on any basis. The stage at which we are is it's the order of the tribunal on joinder that has been set aside. And it's been set aside on one basis, which is the absence of the incorrect interpretation of the 2020 order.
As a matter of form, that doesn't seem to be right because, and this is perhaps an illogicality in the CAC 2 judgment, that, you'll say the only one, they didn't actually say that the the joinder application for Standard Americas is dismissed, which might have been the logical conclusion of its reasoning. They actually said its dismissal application was dismissed, was upheld.
Was granted, yes.
Yes. So it didn't. The CAC didn't actually make an order on the joinder application. It made an order on the dismissal application. And what we have before us is whether the CAC was right to have held that the complaint against SAI, its objection to being a party to these proceedings, should be upheld. And I still don't see why it makes a difference. If the CAC in this case had said, reasoned, this is the meaning of the first judgment, it doesn't permit further joinder. If it had then added, for this reason, we don't need to consider the initiation argument. I'm still not certain, but perhaps you feel you can't say anything more on it, but I still don't understand why they can't, before us, say that even if the CAC was wrong on its joinder reasoning, we are still entitled to support that order on the basis of our initiation reasoning.
No, I think that the difference, Justice Rogers, is really this. Upholding an initiation means setting aside the referral against Standard Americas. That's the only logical way of upholding the initiation point.
Well, I don't think Standard America says we must set aside an initiation. It says we can't be part of this case because there wasn't an initiation at all against us.
No, setting aside in relation to them. I think we're talking about the same thing.
No, well, it would be setting aside potentially the referral against them.
Yeah, sorry, the referral in relation to them, yes. Now, that's the order we would have needed to constitute the jurisdictional fact to debate on appeal, that the initiation has been upheld. And we don't have to speculate here because after everything he has said, he then has a different section called findings. And in that section that is called findings, he says, I'm going to set aside, if you look at paragraph 184, I'm going to set aside the joinder finding because you were prohibited by my 2020 order. So this is made clear in the judgment. The discussion in paragraph 145 is not followed by any consequential relief. And in fact, it's not even conclusory because he says, I'm skeptical about your argument, but he never actually reaches a conclusion on it. It's only 184, and then you read that together with the order. And you apply the standard ways of interpretation of the judgment.
It seems to me your approach, you don't like Stalingrad, and I think nobody likes Stalingrad. Certainly the court wouldn't like it. But this leaves now for another day,
Which,
a fight by Standard Americas on its initiation and joined a point, because you say that hasn't been decided yet. And we can't deal with it because it hasn't yet been decided. All we can do is say that the CAC was wrong in regard to the effect of CAC 1. But that means a point which may be right or may be wrong hasn't yet been decided. Standard Americas is entitled to an answer on it. And if it can't get it here, it will have to get it in some future proceedings before the tribunal.
as well, I suppose you could take that into account in the assessment of what is just and equitable as part of your Section 172 power. And then say, as part of our 172 power, which is a very broad power, one of the factors we'll take into account in deciding to decide the initiation point is exactly the kind of consideration that you're putting to me. But as a matter of law, what you cannot do is to conflate that finding that was made into a finding on jurisdiction in relation to the referral, because the judgment makes that beyond any contestation. If we are in Section 172, which I understand is a possibility to say, look, judicial economy, interests of justice, we must decide everything, including those issues that have not been decided. Yes, then I accept that you have the power to do that. Has Section 172 been invoked here as a basis on which you can decide that? The answer is no. Do you have meromotu powers to invoke it? Yes. If you are at that level, we have made the submissions about the tacit nature of the initiation against all of the participants to this currency fixing.
Thank you. My other question relates to res judicata. You said in response to a question from one of my colleagues that, firstly, this court can say and can correct CAC 1 on the law.
Yes.
Secondly, it then must consider whether, nevertheless, by virtue of res judicata, it remains binding between the parties in this litigation. It seems to me that in principle, not specifically in this case, but as a general matter of law, that puts it the wrong way round. The first question should be, is this point res judicata? If it is not, we can address the point of law. If it is res judicata, the whole point of res judicata is to take it off the table, to mean we shouldn't decide it. We can't decide it in this case. Now, I accept, of course, that this court can, when a judgment of the Competition Appeal Court is quoted to us as a precedent in relation to a matter that is properly before us, we can overrule any CAC judgment and say it was wrong. But it first has to be germane to an issue it is proper for us to decide. And to decide whether your Section 3(1) argument is right or wrong, is properly before us, we must first decide whether it is res judicata. At most, if we found it was res judicata and that there weren't grounds for departing from res judicata, we might say we leave open the question whether CAC 1 was right in this respect. But it seems to me it would be improper for a court that has found an issue to be res judicata to nevertheless say that that point was wrong or right. It would be, apart from anything else, it would be an obiter dictum, because it wouldn't be necessary for the decision in this case.
I think, Justice Rogers, we are debating the form in which the judgment should take. I am submitting that what is appropriate is that you must first decide whether 2020 CAC was correctly decided. And that is a separate issue from whether or not the doctrine of res judicata applies.
For what purpose for resolving what issue that is properly before us, must we decide whether CAC 1 was right or wrong?
Well,
What is the relevant issue?
Well, there's only one issue on that score, is Section 3(1), which you've identified.
Yes. So in order to say that we must decide whether CAC 1 was right or wrong, we have to find that the proper interpretation of Section 3(1) is properly before us.
Yes, correct.
We can only answer that question by first determining whether that issue is already res judicata.
No, I see your point. Then. No, we don't accept that because that's putting the cart before the horse, because you cannot use the doctrine of res judicata to interpret the correctness of a judgment. You use the doctrine of res judicata to decide whether or not I am bound, but not to decide correctness. Correctness is a separate inquiry.
I think in due course we might need to decide whether we prefer your horse or mine.
or your horse. No, I think that's the other way around, but I see the argument that the way you are framing it is, let's start with res judicata and then go to correctness. Yes. My framing is start with correctness and then goes to res judicata.
On the question of departing from res judicata, you correctly mentioned that prejudice would be one factor.
Yes.
Not the only one, and not necessarily decisive. Now, I recall that some of the respondents have raised, but in any event it's inherent in the case, that following CAC 1, there was 3.5 years of litigation based on the footing that CAC 1 had laid down the ground rules for the future conduct of this case. Inter alia, on the strength of that, the Commission filed a superseding referral affidavit. That affidavit had to be examined by all of the respondents. They then filed, and there are probably 14, 15, 16 dismissal applications and exceptions. There are joinder applications. All of that, your client filed answering papers, there were replies. The matter was then argued, I can't recall over how many days in the tribunal, probably 3 or 4. It was argued over 4 days, if I recall correctly, in the Competition Appeal Court. All of this happened on the basis that the parties were testing whether what you had done in your superseding referral affidavit complied with CAC 1, including qualified effects and adequate connecting factors. All of that is wasted effort and wasted costs. Wasted time, wasted effort, wasted costs, if we can now throw CAC 1 out and say it isn't binding between these parties. Isn't that relevant prejudice?
No, not in this case, because they would have had to defend themselves anyway. And the fact that one of the grounds on which they would have had to defend themselves is the issue of jurisdiction. They always had to raise jurisdiction because they always disputed that there were adequate connecting factors. There is no extra cost that comes from a different slant to Section 3.1.
But if the argument was that everything turned only on some effect and that the involvement of the RAND constituted that effect, if that point had been appealed and had been upheld by us, we had accepted your 3.1 argument in an appeal against CAC 1, none of the parties would have taken or could have taken any of the objections which occupied a lot of the time against absence of adequate connecting factors, absence of proper pleading of qualified effects. There would still have been objections about whether there were sufficient facts to show that a particular bank had joined the conspiracy or not. But a lot of this case would have been rendered redundant by a timely appeal against CAC 1.
I'm skeptical, Justice Rogers, and I say this in all seriousness. I'm skeptical about that assumption because even a Section 3.1 pure argument was still met with an objection based on effect throughout in this trial, this particular case that we're dealing with.
In round 2, it was
round 2, yes.
Yes, but that was on the basis of were there foreseeable, direct, and substantial effects.
Yes.
In other words, qualified effects.
Yes.
Your argument is that that isn't the test. If we had upheld in an appeal against CAC 1 your argument that any effect whatsoever suffices, then that line of attack would not have been open to any of the banks.
No, I mean, we still accept effects, but obviously not qualified effects. But because the section itself says effects. Yes. So, yes, that is possibly true that some of the banks could have reconsidered their position. But I am skeptical, having lived this case for 7 years, that that assumption is correct. I think that we would have still been met with jurisdictional objections. I still think, even if you directed them to go back and plead over, I think there is still 1 or 2 objections coming. I'm not as confident as you are, I'm afraid to say.
No, I was raising it as to whether it's not prejudice. I've heard your answer. Thank you.
Okay, thank you, Justice Roger.
I think we've reached that point. We've gone past it, actually. But Justice Matopo has a question. Justice Matopo?
Mr. Ngugaitobi,
It's just,
this issue about jurisdiction troubles me a lot. For the simple reason that if it is against, it's decided against you, what are the possible scenarios available to the competition commission? I'm taking a more practical view, a holistic view about what this case is all about, and asking myself, you did not take the point at KEC 1. This is the debate that I had with Mr. Loxon on the implications, the nature and effect and implications of this plea of res judicata.
we took it in KEC 1.
Yeah, I must say it troubles me.
Yes.
1 and 2,
Okay.
whether you should have appealed or did not appeal, and because you did not appeal, you are precluded, you cannot raise it before us now. And now you're saying it's a matter of law, it's a point of law, you are competent to raise it, but you are met with a plea that says you can't. If you had to raise it, the option was to raise it back then, you can't raise it now.
Yes.
And you're saying to meet with that objection, you would say we should relax it on the basis of the interest of justice. Did I understand you correctly there?
Yes, I have had to embrace that alternative argument, despite myself, because my primary argument was that it's irrelevant, because I'm raising an interpretation of Section 3.1 of the Act. And that's a question of the correctness of the 2020 order, which you have the authority to decide as per Mutsila. That's the primary argument I had raised. And you are not bound by what they decided. You must decide what the law is. Then,
Oh, sorry, I was trying to look at Mutsila, the relevant paragraph. I know I was on the panel, yeah, but I've forgotten what it says. Can you just quote the paragraph?
let's ask Justice Teron.
No,
Sorry, Judge, I don't actually have it.
I have the judgment with me here.
Sorry, I don't have it. I'm going to try to make sure we get it. What is the paragraph?
Because I just want to know what we said there in Mutsila, which you are embracing. Yes.
Yes, I'm told Justice Matopo is 100,
I'm at 100.
101, 102, and 103. So the actual finding is 103.
So embracing Mutsila, you would argue that in 103, we should borrow from what we said in 103 to apply pari passu in this case as well.
Yes, yes. On the correctness issue, not on the res judicata issue, yes.
I'm now worried about precedent, stare decisis.
Well, you have it, Mutsila.
If this is what we said in Mutsila, and we are urged to say something different in this case, and we may take the flag of inconsistencies with our judgments, unless if your reading of Mutsila, I still have to apply my mind. Unless if your reading of Mutsila, it's not opposite. It can be said to be distinguishable.
Yes, I mean, there, I mean, legal reasoning is an elastic thing. But you could say that this case, we have to decide res judicata first, and therefore we don't engage Mutsila at all. And that is a point of distinction. But again, in this elasticity of legal reasoning, you could also say that the correctness as to jurisdiction is such a fundamental issue, which is what has been cited here from cases like May's Board. And you will not allow a jurisdictional finding to stand, because that will perpetuate a legal wrong inconsistent with the statute. And you take it as a matter of principle and decide, and Mutsila would be good authority for that.
I need to think about this. But as you know, as you may have been aware over the days, it has been a source of concern for me.
Yes, no, I appreciate
I don't have the answer yet.
Yes.
I have listened to the forceful argument by Mr. Loxton on the point and Mr. Cockrell as well, and your equally persuasive argument on this.
Well, I hope I'm the only one who's persuasive. Thank you, Justice Muto.
We will, is there a question? Okay.
Toby, just one question from my side. You've urged us in embracing the idea that there was a single overarching conspiracy to conclude that the only reasonable inference to be drawn is that all of the respondents were part of that conspiracy.
Yes.
You don't suggest that there were bilateral agreements, but if they were part of a conspiracy. Or,
Yes.
And as I understand your argument, your suggestion is that if two traders were in a chat and the chat evidenced conduct of fixing,
Yes.
then the fact that the other trader was in other chats
Yes.
would be sufficient to draw the inference that this trader who was in a single chat was part of a conspiracy, correct?
Indeed. Thank you.
Now, just arising from that, when I look at the referral affidavit, and the referral affidavit deals with the direct, immediate, and substantial effect test, even though you don't primarily rely on that test, you rely on the effects test, correct?
Yes.
Now, under that section, there are two sort of subheadings, and the one deals with foreseeability, and the other deals with the cumulative effect.
Yes.
The tenor in both those sections speaks of both the period of time
Yes.
and persistence.
Yes.
So the suggestion is that time and persistence are in fact relevant considerations in the conclusion
Yes.
around foreseeability, around cumulative effects, and fits into that mode.
Yes.
When one then posits that against single conduct, for example, could it be said, well, there are two inferences that could be drawn. The one, that even the single conduct provided with somebody who's involved in other type of conduct may lend itself to the reasonable inference that you're part of the SOC.
Yes.
But another inference that could be equally reasonable could be that's an isolated incident. And the fact that you're associated with Mr. Ayer, for example, and if Ayer is involved in other chats, that may not be a reasonable inference under those circumstances, especially in the light of the assertion by the Commission that time and persistence would be a factor. How does one deal with time and persistence in the context of lending itself to a reasonable inference when it might militate against that?
Well, Justice Kolopin, firstly, I accept that time and persistence are relevant. They are actually very strongly relevant. Yes. And I accept that instances of singular participation would also be relevant, but not decisive. And then if you are in that mode, you then have to look at other surrounding factors. And those surrounding factors then could be the nature of the collusion, the currency pair that is engaged, the counterparty to it. And then, bearing in mind what is said, and I'm very grateful that you've taken us to the effects section, because it's actually a strong section on knowledge bearing in mind what they knew. If you look at 275, the last sentence there about what they knew. The traders were aware of this when they engaged in the collusive conduct and posted quotes, or in some cases withheld quotes, on international trading platforms with the aim of manipulating the ZAR. So that's what they know. They know what the effect of what they're doing, even though they are purporting to be acting bilaterally. Then in 276,
Could I just interrupt you on that? Would you disagree that when you say the traders would have knew that that's a conclusion?
no, it's supported later if you look at 466, because I've also taken that note into account. Why did they know 278? The traders could see in real time the effect of their manipulation of the currency exchange and the lasting impact on the bid-ask spread. So they could see, as they were doing it, what was going on to the currency.
Sure.
It's not a conclusion without fact. It's a conclusion plus fact.
But is it not equally be contendable that even in a bilateral relationship they could see? And that doesn't necessarily lend itself to reasonable inference that they were part of a conspiracy. What I'm saying, it could cut either way.
No, the problem with that is that it can't cut either way if you look at what they could see is the impact. Because if you look at what they could see is the impact, there's no reasonable way that a pure bilateral once-off chart could have these catastrophic impacts that are described in 275 to 279. So what they could see, which was going on in the global markets on the trading of the rand, is only consistent with knowledge of the conspiracy as a whole, completely inconsistent with knowledge only of that bilateral conversation. And the last thing on this point is just to refer the court to the findings of the tribunal at 132, paragraphs 132, I think these are in volume 2. Volume 2, volume 3. But in the judgment of the tribunal is 133, 134, 135. And then it goes on to 143. Because they examined this in detail, this question of what could be inferred from what was happening. And then it said, when you look at the entire picture, it is fanciful to think that these traders only knew that once-off chart. The actual realistic way of understanding this is as an integrated system of collusion. And interestingly, these findings are actually just not dealt with at all in the CAC finding.
Okay, thank you, Mr. Dukaitobi. Thank you very much.
Thank you, Mr. Chief Justice.
I don't think there are any further questions, so we're going to take our 15-minute tea break. And when we come back, we're going to deal with the cross appeal. See, Mr. Cochran is ready. Court adjourned. Advocate Cockrell, you can go ahead, please.
Thank you, Deputy Chief Justice. Before my 15-minute begins, I've been asked to raise an issue of housekeeping on behalf of my learned friends. The Commission was asked to prepare a note on disputes in issue by Justice Rogers. The note was provided to us yesterday, I believe it was. We haven't had a chance to respond to it. And so the purpose of my request is simply to ask whether you would give all of the banks leave to file a response to the list of legal questions. I've got no instructions about how long it would take, but it would be a few days, I would imagine. That's just my request, and I'm just the messenger, Deputy Chief Justice.
Well, I'm surprised by the lateness of that request, because when I asked yesterday whether it's been shared, I had nothing, so I thought there was no issue. But certainly.
Thank you.
But only not to re-argue anything. So we'll grant that.
Thank you very much, Deputy Justice. There will be no re-arguing. It's just an attempt to respond to the list of legal questions that the Commission prepared.
List of legal errors, I think. List of...
correct.
English is not my first language.
Thank you very much. Thank you very much, Deputy Chief Justice.
As long as that's clear, it's not an opportunity to re-argue anything.
Yes.
It's just to respond to that note.
Deputy Chief Justice, I can only respond on behalf of my client, and my client won't re-argue the matter. But
You, the messenger, you'll tell them.
I'm the messenger. I'm sure my learned friends won't abuse the occasion either.
Thank you.
Thank you, Deputy Chief Justice. As you know, I act for two HBSC entities. The one is HBUS and the one is HBU. This address is an argument on behalf of HBU. HBU is the applicant in the application for leave to cross-appeal. And you'll know that HBU is a local peregrinus because it does have a presence in South Africa. And the essence of HBU's cross-appeal is that although the Commission has jurisdiction over it, the Commission has the wrong guy, to use that phrase. What we know is that the Commission cited HBU as the employer of Mr. Hutton, when in fact it was a different entity within the HSBC group that employed Mr. Hutton. And that's the argument I'm going to develop today in my 15 minutes. I want to spend most of my time in arguing for why the Commission has the wrong guy. And that will take up most of my 15 minutes. And then if time permits, I'm going to make very brief submissions regarding why the correct procedure was used by HBU in order to take the point. And then finally, if time permits, I'm going to deal very quickly with the requirements for obtaining leave to appeal, or in this case, leave to cross-appeal. So those are the three issues I intend to address. And let me then start with the major issue, which is that the Commission has the wrong guy. Deputy Chief Justice, in order to come home, what the Commission has to persuade this court is that either the conduct of Mr. Hatton or the conduct of Mr. Merkovich or the conduct of unnamed traders could be attributed to HBU. There are only three possibilities in that regard. It's the conduct of Hatton, conduct of Merkovich, or the conduct of unidentified traders. I'm going to take that in reverse order, if I may, and let me start with the unnamed traders. Now, the Commission's averment is so vague in this regard. All we are told in paragraph 66 of the founding affidavit is that the conspiracy was implemented by various people whose details are unknown to the Commission. And our respectful submission is that averment doesn't get off the ground. It doesn't even suffice at any level of pleading. The Commission says various people implemented the conspiracy, doesn't know who they are. So to try and suggest that HBU can be attributed with liability for the conspiracy on the basis of that averment, in our respectful submission, is simply a non-starter. That brings us then to Mr. Merkovich. And Deputy Chief Justice, the only way I can deal with this is to ask you and the members of the court, please, if you'll go to paragraph 97 of the founding affidavit. It's paragraph 97. It's on page 411. And in paragraph 97, and again in paragraph 217, there you'll see the only allegations which seek to attribute liability to Mr. Merkovich. And the allegations are so vague and perfunctory that, with respect, they simply don't bear any serious consideration. The one allegation is that Hatton made reference to his conversations with Milo. We know that Milo, or Mijo, is Mr. Merkovich. And the other allegation is that Ayer said that Milo had taken 15. Now, whatever those averments mean, they are far too vague to suggest that any liability can be attributed to H. Bew for the conduct of Mr. Merkovich. So we respectfully submit that Mr. Merkovich is also a non-starter when it comes to ascribing liability to HBU for the SOC. And that brings us then to Mr. Hatton. Now, we accept that Mr. Hatton is implicated in a number of chats. However, the problem in our respectful submission for the Commission is that there's no evidence to show that Mr. Hatton's involvement was in his capacity as an agent for HBU, that's the European entity, rather than as an agent for HBAS, which is the American entity. And for me to develop that argument, let me start by asking you to go to the inference that was drawn by the CAC. This is in CAC 2. You'll find it in paragraph 135. And I'm just going to read it to you to save time. What the finding of the CAC was in paragraph 135 is that while the 19th respondent, that's HBAS, admits that Hatton was its employee, the allegations of participation in trading contained in the referral affidavits entitles the drawing of an inference that the 14th respondent, that's H. Bew, has been correctly connected to the SOC. Now, with respect, that finding is just devoid of any logic. What the CAC says is, because H. Buss was involved in the conspiracy, it justifies an inference that H. Bew was also involved in the conspiracy, and in our respectful submission, there's simply no logical basis for drawing that inference. And the position becomes particularly marked when one now compares what the CAC said about the other banks to what the CAC said about H. Bew when it came to drawing the inference. And can I ask you, please, if you can go to paragraph 88 of CAC 2. And let me read you, again, just to save time, let me read you the finding in paragraph 90. The finding of the CAC was the Commission also alleges that Cook and Shepard were employed by and or representing Merrill Lynch, alternatively Bank of America. They were authorized by Merrill Lynch, alternatively Bank of America, to trade in the US dollar ZAR currency pair on its behalf. This is devoid of the kind of specificity which was required by the 2020 order or by a referral that could pass legal muster. So what the CAC says is those averments are too lacking in any specificity for liability to be attributed to the relevant banks. But with respect, those are exactly the same averments that were made in relation to HBU. So the oddity, and I say this with respect, the oddity of the CAC's position is they say in the case of the other banks, there's no basis for drawing an inference that liability should be ascribed to HBU. But when it comes to HBU, on the basis of exactly the same averments, they say there is a basis for drawing the inference that liability should be ascribed to HBU. Now, I've elaborated on that submission, but exactly the same finding is made in two other paragraphs of the CAC judgment in CAC 2. The one is in paragraph 125, and the third is in paragraph 66. I don't have the time to take you to those paragraphs. I would ask you to read them in due course. And when you read them, the question to ask yourself is, how did the CAC draw the inference against HBU, but not against those three banks when the factual allegations were exactly the same against HBU and against the other banks? If I go on then to the factual position regarding Mr. Hatton, let me try and cut through some of the clutter, Deputy Chief Justice. There are two issues which emerge on the pleadings. The first is whether HBU employed Mr. Hatton. The second is whether HBU authorized Mr. Hatton to trade on its behalf. Now, the first issue we understand to be a non-event because my learned friend, as I understood it, very fairly made the concession yesterday that it's not the Commission's case that Hatton was employed by HBU. And if you need any support for that, if you go to paragraph 65.7.1 of the founding affidavit, you'll see that is not the Commission's pleaded case. What the Commission's pleaded case is the one we find in paragraph 65.7.1. And there we find the allegation that Hatton was authorized by HBU to trade in the US ZAR currency pair on its behalf. So that's the only hook that the Commission can use to try and get its tentacles into HBU. The averment that Mr. Hatton was authorized by HBU to trade in the US dollar ZAR currency pair on its behalf. And with respect, I'm going to give you a number of reasons why that bare averment doesn't suffice for the Commission to make out its case. I need to refer you to some law in this regard. The first is the judgment of the CAC in Graylio. It is referred to in our heads of argument, the judgment of the Competition Appeal Court. And Graylio, paragraph 42, makes it clear that without proof of authority, the Commission's case doesn't get off the ground. And then the other authority I want to refer you to is one that isn't referred to in our heads of argument, but I did tell my learned friend last night that we intended to refer the court to it. It's ESCOM versus Soweto City Council, 1992, Volume 4, South African Law Report 703, the judgment of the Witwatersrand Local Division, and the relevant passage is at 706C. Now, in the light of those two authorities, I want to make 4 submissions to you in the time available to me. The first is the Commission has put up no evidence whatsoever in support of the averment that HBU authorized Hatton to trade on its behalf. There's no evidence in that regard, and the averment clearly falls outside the knowledge of the deponent. How would the deponent have any knowledge about the authority of Hatton? Well, he or she doesn't explain it. And what we do know from the papers is that the Commission never investigated whether Mr. Hatton had authority to trade on behalf of HBU or not. So the allegation is a simple allegation. It's made very fleetingly and by someone who couldn't have any knowledge of that fact. That's the first submission. The second submission is the Commission's averments regarding authority of Mr. Hatton. They are simply cut and pastes of the similar averments which are made against all the other respondent banks. I'm going to give you a number of examples. I don't have time to take you to them. In the founding affidavit of the complaint referral, if you'd have regarded paragraph 65.2, 65.3, 65.4, 65.5, 65.6, and then the pattern carries on. The allegation is made that there was authority on behalf of the relevant traders, but there's simply no proof in that regard. The Commission's allegation is simply a cut and paste of the averment that they put up in the case of the other banks. The third submission I want to make is, in competition proceedings, it's not sufficient to plead legal conclusions as it would be in action proceedings. So in action proceedings, you can get away with drafting a very skeletal set of particulars of claim. But the whole point of Rule 15.2 of the tribunal rules is to say that there's a burden, I don't mean it in the legal sense, but there's a burden on the Commission to substantiate the averments and to plead the material facts. So it was therefore incumbent on the Commission to tell us what is the factual basis for the averment that they rely on to say that Mr. Hatton had authority to bind HBU, and there's simply nothing there. The fourth submission I want to make is that the Commission is not an ordinary litigant. As you know, because you've heard from my learned friends about this, the Commission attracts certain duties which do not attach to ordinary litigants. And our respectful submission is it was quite inappropriate and improper for the Commission to make this unsubstantiated bald averment regarding the authority of Mr. Hatton. And in doing so, they circumvented their constitutional obligations. Now, you heard my learned friends, Ms. Hofmeyr and my learned friend, Ms. Engelbrecht, on this. I'm not going to repeat their points, but we would simply support all of the submissions they make regarding these throwaway averments, which do not suggest that the Commission has investigated the matter. On the contrary, suggests that the Commission has simply absolved itself of its constitutional obligations to investigate the matter before they throw out these unsubstantiated averments. And so for all of those reasons, Deputy Chief Justice, our respectful submission is it's a very narrow point. The narrow point is there any basis for this court to find that Hatton was authorized by HBU to trade on its behalf? And our respectful submission is there is no basis for that. And once that's the case, the whole case against HBU simply implodes. Because if there's no authority on behalf of Mr. Hatton to trade on behalf of HBU, the whole case simply ends. Deputy Chief Justice, I wanted to make two other submissions. The first is regarding the procedure used by HBU. Well, we submit that it was an appropriate procedure. If you listen to what I've argued, I haven't actually relied on any facts which have been put up by my client. I've relied on the Commission's facts. And so we respectfully submit that the use of an exception procedure was entirely appropriate. And then the very last submission on leave to appeal, we respectfully submit that this is an appropriate case to grant my client leave to appeal. And Deputy Chief Justice, I'll elaborate on those submissions if necessary, but those are my submissions. Thank you very much.
Thank you, Mr. Cockrell. We're then going to ask you some questions.
If there are no other questions, since you were cut off, you would have heard a number of your colleagues who are opposing the Commission's appeal saying that questions of the assessment of the adequacy of the pleading doesn't engage this court's jurisdiction. It's just a mundane question. If the appeal court misunderstood the facts, misread it, weighed them incorrectly, none of that engages this court's jurisdiction. Why do you say the CAC's alleged error in this case concerning your client engages our jurisdiction?
Yes, Justice Rogers, will you just let me find my notes in that regard, please, because there's a short answer to that. Yes, the Commission actually concedes it in their answering affidavit in Volume 12, page 111. The Commission's answering affidavit in HBU's application for leave to cross appeal, paragraph 20.2. The Commission concedes that the cross appeal of HBU raises both an arguable point of general public importance and a constitutional matter.
Well, we're not bound by that, and I'm not sure whether perhaps contentions were advanced in your application for leave to appeal which go beyond the point you've argued now. But what do you say is the arguable point of law of general public importance concerning the question whether the allegation of authority suffices?
It's the duty that binds the Commission to investigate complaints before making the referral in our respectful submission, Justice Rogers.
It's common cause that must be done.
Yes.
You may say it wasn't done here, but we don't need to decide that the Commission, as a responsible regulator, should properly investigate before it refers.
We say it wasn't done, though. And
yes.
We say it wasn't done.
What's the point of law we must decide, or do you say that's a constitutional issue?
It could be a constitutional issue with respect, because it's feeding into a broader debate regarding the duties that attach to a regulator before advancing unsubstantiated averments against respondents. And so we say it's a constitutional matter because it's dealing with the issue of what duties attach to an organ of state before they make these sort of averments. So it would be a constitutional matter in our respectful submission.
Yes, I'm not sure all your colleagues for the respondents will like that answer, because then we would have to say that all the allegations about insufficiency of pleadings against them also raises a constitutional matter.
That's the answer I give for my client, for my client, Justice Rogers. You know, if we need to go into the non-constitutional matter, the issue would be, well, it's just a variation on the theme. The issue would be the Commission makes the allegation, but there is no basis to support it. But that's just a variation on the theme, Justice Rogers. I'm not sure I can take it very much further than that.
I mean, is the question whether it suffices for the Commission merely to allege somebody's authority, or whether they need to... Do you say there's any doubt on the law? Rule 15.2 requires the pleading of material facts.
Yes.
The statement that somebody is authorized, I think on the face of it, is a conclusion.
Yes.
Authority can flow from a variety of different facts. The question is, what is the material fact which justifies the conclusion that somebody is authorized?
Yes.
But Rule 15.2 is clear that material facts must be pleaded. So it doesn't appear that there's a question. We don't have to interrogate the proper interpretation of Rule 15.2, but we'll hear from Mr. Nkatobi for the Commission. Maybe he says a mere bare allegation of authority does suffice, and maybe that will raise a question of law that we must decide.
Yes.
As to the scope of material facts for purposes of Rule 15.2.
Yes. Justice Rogers, may I make it clear? I'd assumed it was common cause between us and our learned friends that the issue raised in the cross-appeal was a constitutional issue.
Yes, but
I accept that you are not bound by that. Of course I accept that. But the dispute between us and my learned friend is effectively a non-dispute, because the Commission concedes that it is a constitution, it is a matter raising a general matter of public importance.
thank you.
Mr. Cockrell, in respect of what HPEU calls a dismissal application, isn't it really complaining about non-compliance with Rule 15.2?
Yes.
Isn't that properly then an exception?
Justice Turan, may I just try and get clarity on where the question is going? Is the concern about the matter not being appealable, or is there some other concern that you want me to address?
Do you want to address my questions that may still arise? Or I'm not sure why you're asking the question.
Yes. No, I'm just trying to get clarity and trying to shorten the debate.
I'm trying to understand what is a dismissal application. Trying to understand where provision in the rules of the tribunal is made for a dismissal application.
Yes.
When the complaint relates to non-compliance with Rule 15.2 of the tribunal.
Yes.
And if that's the complaint, then an exception should have been filed.
Yes. The proceedings brought by my client HPU was not a pure exception. It was a quasi-exception, if you like.
Then why didn't they file it as a quasi-exception? Why bring a dismissal application which none of us seem to be familiar with?
Because of the history of the matter, Justice Turan. So there's a long history of the matter which is set out in our heads of argument. We've tried to give you a potted summary of that. So the reason why this dismissal application was brought was because the CAC gave the Commission a second chance to plead these averments and to plead them properly. And when that invitation was not accepted by the Commission, my client considered the only way to secure appropriate relief was to ask for a dismissal application. Now, the dismissal application was formulated as a dismissal application, but in the alternative, declaratory relief was sought to the effect that the Commission hadn't complied with the relevant tribunal rules. So that alternative relief would also allow us to come home if the court were of the view that the dismissal was inappropriate. But our primary submission is, in the light of the history of the matter, in the light of the fact that all of the invitations by the tribunal and the CAC had been spurned by the Commission, it was appropriate in our submission for my client to ask for the matter to be dismissed. That is our submission in a nutshell.
If we have to allow parties to have regard to their matters and the history of their matters,
Yes.
and circumvent compliance with the rules, That would lead to some kind of chaos, would it not? Surely, if you want to bring a procedural challenge, you must do so in terms of the rules. If you want to bring an application, or any application must be brought in terms of the rules of procedure.
It's not.
And it just doesn't seem to have merit to justify circumventing the rules on the basis of the history of a matter.
But Justice Turan, with respect, the history is critical. So may I try and answer your question this way? If one tries to straitjacket HBU's application, you may say, well, it wasn't formally an exception. But with respect, the tribunal doesn't work in those rules. So the approach of the tribunal is not to straitjacket the parties into bringing an exception within the meaning of the rule. And the tribunal has been quite clear in other cases that it is more than prepared to give the parties the latitude to bring other applications that are just and equitable within the meaning of the rules, even if they are not exceptions proper. And in this case, the tribunal had no quibble with the fact that my client asked for a dismissal application. And indeed, Justice Turan, if you look at all of the other respondents who are in the room, most of them here also didn't bring exceptions proper. I can't say most of them, some of them didn't bring exceptions proper. So if you were to find that my client utilized the wrong procedure, you would also be, in effect, be making a finding that in the case of the other litigants, they also used the wrong procedure. But our fundamental submission is this: the tribunal is not straitjacketed by procedure. Its rules are more flexible, and it was entirely appropriate in this case for my client to ask A, for dismissal, alternatively for a declarative that the rules had not been complied with.
If I understood your earlier submissions, Mr. Cockrell, you said that what is missing is the factual basis for the averment that Mr. Hatton had authority to bind HBEU.
Yes.
And that basically would justify HBEU to bring an exception. But anyway, let's move on.
Yes.
If I recall the papers correctly, HBEU does not rely on an arguable point of law for jurisdiction in this court.
Justice Turan, I don't want to make my learned friend's life more difficult, but his concession was both legs of the jurisdictional...
I'm not asking about his concession. I'm asking about HBEU's case.
I'll have to ask my learned junior just to look that up. I don't want to waste the time, but I just can't recall, quite frankly, Justice Turan.
Because, like Justice Rogers, I have difficulty finding the arguable point of law or the constitutional point that arises in this matter.
Justice Turan, I don't have the record to hand. I'm going to ask my learned junior to look that up, and perhaps I can come back to you about that in due course, if I may.
Yes, you may.
Make it clear, I'm not trying to duck the question. I just don't want to waste the court's time there.
Yes. Yes, you can address it later, Mr. Cockrell. Those are the only questions I have for now.
Come back to Justice Turan.
Yeah, Mr. Cockrell, while they're checking there, can I ask you, may I just say on jurisdiction, just to add to this, I got another question on your argument. On jurisdiction, it seems to me your argument is based mostly on this, that the CAC got the factual analysis wrong as far as Hatton is concerned, and as far as Mijo Merkovich is concerned.
Yes.
Isn't that beyond the scope of our jurisdiction?
Well, if you strip out, if you boil away the bluff, the complaint is that HBEU was not treated the same as the other respondents, even though they were similarly placed. And it's that lack of equality of treatment that ultimately would ground the constitutional complaint. The complaint is that the CAC ought to have drawn a similar inference in the case of all of the banks, but it drew the inference against HBEU, but didn't draw a similar inference against the other banks, even though the facts were effectively the same, Justice Majid.
Well, that's actually my question that I want to ask you.
Yes.
There's no authority. Let me rephrase that. There is authority in this court that similarly placed litigants are not entitled to a similar outcome. That's Metcash.
Yes.
So you can't, because a litigant in a certain position has been treated like this and you've been treated differently, say then that you're entitled to the same outcome. How does Metcash affect this argument that you say, because there's a different outcome, therefore the court has jurisdiction?
In Metcash, there were two different courts, Justice Majid. In this case, it's the same court. So the same court, dealing with the same record, draws the adverse inference against HBU, but doesn't draw the same inference against the other banks. So we would respectfully submit that Metcash is distinguishable on that basis. It's the same court. It's the same court.
I would have thought the principle would be the same, remain the same, even if it's the... I would have thought the principle would be the same, even if it's the same court.
But that's the complaint. The complaint is that my client was unfairly treated, if I can put it that way, precisely because the CAC drew the inference against my client but didn't draw the same inference against other banks on exactly the same pleadings. That is the source of the complaint.
And do you say that implicates its any constitutional right, and if so, which one?
Well, I need to just work, I need my learned judge to tell me whether the case was pleaded or not. I don't want to give an off-the-cuff answer which isn't the pleaded answer. So can I come back to you on that as well?
Yes, I must tell you, my notes here, my summary says that you pleaded both, but my note may be wrong, of course.
Yeah.
But anyway, that was the only question I had. Thank you, DCJ.
Go ahead. Of the applicant for leave to appeal. Would you just find it to me?
Mr. Cockrell, I'd be happy if you just make the submission that you're pleaded both. I take your word for it. It's more likely I'm mistaken than you.
I'm sorry.
I would be happy to accept your word that you're pleaded both a constitutional issue and an arguable point of law, and accept that I may have been mistaken. If that's your instruction from your junior.
Well, I'm not sure it is, and I wouldn't want to mislead the court. So I'd rather give you chapter and verse, Justice Tarani, if I may, just so that it's not my mistake.
Should we give you some minutes, Mr. Cockrell? Or you'll deal with it in reply? Huh? Mr. Cockrell? You mind dealing with this issue in reply, or have you found something?
I've been given a reference which is not a helpful reference with respect, Deputy Chief Justice. So may I deal with it in reply? So
You make your election now. You want to deal with it in reply?
yes, I don't want to waste the court's time. So if the short question is, was that point pleaded or not, I'll be able to address that very quickly in reply.
Okay.
Maybe that would also deal with your question, Justice Majid. I don't know whether it will, but hopefully it will be.
Okay. Thank you very much. That will be all for the moment. Advocate Mugai Toby.
Could I argue from Mr. Cockrell's notes? Thank you, Deputy Chief Justice. I think that let me probably shorten this. My learned friend relies on three things when he says that the Commission's pleaded case is deficient. Let me deal with each one of them. The pleaded case on the authority of Hartin. Let me just focus on Hartin and forget about Mijo for a second. The first authority that he cites is ESCOM versus Soweto City Council, which is a judgment they gave us yesterday. It's reported in 1992, volume 2, SA 703. It's of the old Witwatersrand local division, a judgment of Fleming DJP. Regrettably, it's irrelevant to what we are dealing with here. It is a case about whether a person who institutes proceedings on behalf of a juristic entity has shown authority to bind the juristic entity when instituting proceedings. And there, the deponent it had stated that he was authorized to make this affidavit. And then the argument was that is different from authority to bring the application. And that's a totally different issue. It's an authority to bring proceedings. has nothing to do with the authority to enter into collusive agreements in the competition sense. So case number 1 is irrelevant. Case number 2 that is referred to is Gralio, which is a competition appeal court case. It's a judgment of Dambuza J.A. The relevant part, it's at page 1693 of the authorities bundle. It's in paragraph 12 where there is some relevance. It was an issue about the trial. So the trial, a cartel trial, had run its course, and one of the defenses of the alleged cartelist was that the person who concluded these agreements on my behalf was not authorized. And that is what they dealt with in paragraph 12. The tribunal found that there was no evidence that the respondent had participated in the alleged concerted practice, and further that the appellant had not proved that Hansen had authority to represent the respondent and to agree and bind it in the participation of the cartel activities. The tribunal also found no basis in the evidence from which it could be inferred that Hansen had or would have conveyed the resolutions or agreements concluded at the cartel meetings to those in authority within the respondent. So again, that is irrelevant to the question of pleading authority at exception stage. Then the third one is then Rule 15.2. And the basis for invoking Rule 15.2 is that it says material facts must be pleaded. 2 days ago, we relied on the judgment of the Supreme Court of Appeal, which answered this issue, that the pleading that a person is duly authorized is sufficient to withstand an exception. That's the, not C, I think. Just want to get the name of that case now, as escaping.
View Shopping Center?
Yes, Northview Shopping Center, paragraph 28. Now, the question then is, that was a judgment deciding sufficiency of pleadings under Rule 18 of the Uniform Rules of Court. Under Rule 18 of the Uniform Rules of Court. Now, Rule 18.4 of the Uniform Rules is worded identically to Rule 15.2. Your pleading must contain sufficient facts, material facts, not sufficient, material facts. And that has already been interpreted to mean, in the context of an exception, it is a sufficient material fact to say that a person is duly authorized to take a particular action. So that would actually be dispositive of the entire debate about Rule 15.2 and the material facts. And then the final thing to be said about this is that the actual pleading in relation to HBEU, which is the United Kingdom entity, explains the basis for drawing the inference that they were duly authorized. And that is at page 472. So it's actually not a bold averment. So it's 471 from paragraph 303 and 472 at 304 and 305. It says in 305, the 14th and 19th respondents are members of the same group of companies and are therefore directly or indirectly linked to one another. Now one can say, I don't like that way of attributing authority, but one can never argue that authority is not factually pleaded. What is the basis for inferring authority? So what that means is that the three arguments that have been raised, none of them actually can be sustained. When we then go back to Hutton, what we know is there is a group of companies under HSBC. The Commission has some facts that implicate HSBC, and then it pleads in the alternative. You are either employed or duly authorized. The fact that the UK entity did not employ is irrelevant. It does not mean that it did not authorize. And the question whether it did or did not authorize is a question of fact that will be decided, like it happened in Gralio, at the trial. It is not something to be dealt with at exception. Thank you, Deputy Chief Justice.
Thank you very much. Advocate Mokatobi, I think my colleagues, if they've got questions, they will ask you. Okay.
Any rethink about the concession and jurisdiction?
No, I am not going to even do that. It will bite me tomorrow in another case. So.
Mr. Mugaitobi, the complaint really is that the Commission did not comply with Rule 15.2. It didn't make, and this is specifically now in relation to proceedings in the Competition Tribunal, that it didn't comply with the rule that says that it should not just reach legal conclusions, but make a factual basis to support the legal conclusion. What do you say about that?
Yes, that we say, based on SCA authority, it's the same wording, Rule 18.4, place material facts. The question is, when you say you are duly authorized to enter into an agreement, is that a material fact sufficient to meet an exception objection as per Rule 18.4? The SCA authority on that point is clear. You then come to the competition context. The exact same wording is used in Rule 15.2. And that authority would then be dispositive of that question. It would be sufficient to say this person was authorized by this entity to enter into trading. But in the course of that, they abused that authority and entered into collusive agreements. And then I say, in addition to that, the factual basis for that authority is set out in the pleading, because it is explained that we say he is authorized because he is representing a company that falls within a group of interrelated sister companies.
And the applicant accepts that it's not sufficient for the link between HBEU and the other HBUS that can be drawn simply because Mr. Hatton worked for a company within the same group, that the Commission accepts it has to go further, and this is why I would assume it's relying on the authority.
Yes, that's why we rely on the authority. The problem, of course, you find, Justice Teron, in these sort of things where somebody breaks the cartel. It's what typically happens. They break the cartel, and they decide, let me go and confess. And then they give you information, some of which is cryptic, because that's how a cartel operates. And what you see in that information is that it refers to HSBC, and HSBC comprises of 4 companies. You are perfectly entitled to say Company A, because they're all in the same stable, Company A or Company B or Company C, and then say the trial will sort out whether or not that trading did not benefit the UK entity. It's not appropriate at exception stage to try and defeat it.
Yes. Thank you, Mr. Mukatawi. Thank you, Chief Justice.
Thank you, Advocate Ngogatobi.
Thank you, Justice.
Thank you. Advocate Cockrell,
Yes.
do you have a reply?
Thank you. Justice Turon and Justice Majid, I said I would come back to you about the pleading. So it's paragraphs 49, 50, and 52 of the application for leave to appeal. And you'll find that on page 1081. So it's the application for leave to cross appeal of my client. I'm going to read it to you because it is also an answer to the substantive questions that I was asked. The issue consequently raises arguable points of law concerning the equal treatment of respondents and when a respondent's bank may be held liable for the conduct of a trader that it does not employ and who is not authorized to trade on its behalf, but who is employed by a different entity within the same group of companies. It also raises the question of what standard of pleading the Commission ought to be held by. The HBU submits that it has strong prospects of success. We don't need to go with that. In circumstances where the Commission may not know the identity of the firms within a group of companies, the Commission is required to exercise investigative powers properly and evaluate the alleged contravention. It is not permitted to adopt a shotgun approach, citing the firms within a corporate structure in the hope of correctly citing someone. It is this failure to exercise its powers properly, which is a matter of general public importance and which ought to be properly considered by this Court. It also raises the constitutional issue as it concerns the Commission's exercise of its powers. And then in paragraph 52, the conclusion, I therefore submit that the issues in this cross-appeal raise both, and I would interpolate, a constitutional issue and B, an arguable point of law of general public importance. So that is the response as a matter of pleading. And as a matter of substantive law, what I would say is it's, with the greatest of respect, in competition proceedings, it's not enough to get by with a skeletal averment of authority. The whole point of the Competition Commission is that it has vast powers to investigate, and if it's going to discharge those duties properly and diligently, it must investigate whether HBU did in fact authorize Hatton. What we know from the record is that there was not a single question asked to HBU in that regard. So the Commission stood by its guns, it stood by the pleading. My learned friend now says, well, he can get away with that because of the SCA judgment that he cites. But with respect, in the case of competition matters, one would expect something more of the Competition Commission, rather than to get by with a bald allegation of authority. And that bald allegation of authority has led to all of the consequences that you've heard. 8 years later, my client is still facing a complaint. My learned friend says, well, maybe he'll be able to prove the authority in due course. But if he doesn't, the expenses are going to rack up. And that is simply something that should not conscionably be permitted by a regulator in our respectful submission. Deputy Chief Justice, that is the response to the matter of substance my learned friend raises, and also to the matter of pleadings that Justice Theron raised. That's it. Thank you.
Mr. Cockrell, you know what worries me about this stage of the matter is that we're at exception stage. And shouldn't we be worried with wanting the Commission to give evidence and to give proof at this stage? Yes, at the trial stage, they would have to give those. But I'm just worried that we're at an exception stage.
Yes.
And all that 15.2 requires is concise statement of facts.
Yes.
And I'm thinking that if all that the Commission could say at this stage is that Hatton was employed by one of the companies within that group,
yes,
then during the evidence stage, and probably at that stage, there would be discovery proceedings as well, and there would be probably a pre-hearing meeting and all of that. All those things will become clear. I'm just worried about us in this court saying that the Commission has to give more than it has given in this matter. And I'm worried that we would be treading onto evidence.
yes. Justice Cheeky, I understand the concern. It's a concern that has reverberated throughout this hearings, and I'm aware of the concern. What I would say is, just look at how narrow the dispute is. It's common cause that H. Bus employed Hatton. That is common cause, not disputed on the pleadings. The only dispute is not whether HBU employed Hatton. That's not a case the Commission relies on. The only dispute is whether, even though Hatton was employed by H-Bus, not by HBU, was Hatton nevertheless authorized to trade on behalf of HBU? That's how narrow the dispute is. And that is the issue that is going to have to be ventilated in a trial. And in our respectful submission, it's not inappropriate for this court to cut through all of that and say the Commission had the powers to investigate the authority of Hatton. It was required to investigate whether Hatton was authorized by HBU. I've made the submission. The deponent says that HBU authorized Hatton, but the deponent couldn't have any knowledge of that, and the deponent doesn't claim to have any knowledge of that. So it's a throwaway averment, and on the basis of that throwaway averment, in our respectful submission, our client will have to sit through the competition proceedings in due course. And it's that outcome that we seek to avoid with respect. I'm alive to the concern. I really am very much alive to the concern. But I've tried to make the dispute as narrow as I can. The sole issue is whether HBU gave authority to Hatton to trade on its behalf. That is as narrow as the dispute is. If you find yes, well, then my client is in for the long haul. If you find no, my client is off the hook. And that is ultimately the matter that you are seized with.
So we should take prejudice to your client when we're deciding this fact?
Yes, very much so. The prejudice is made out on affidavit. The prejudice is made out that my client has suffered 8 years of this complaint already, and the complaint is going to continue. That is the case made out in our affidavit, Justice Nchiki. Yes.
Okay, thank you, Mr. Cora.
Mr. Cockrell, would it make any difference to our approach if, say, for example, we uphold the Commission's appeal in respect of HBUS,
Yes.
so that it's going to be in the case anyway,
Yes.
at least up to now represented by the same team?
Yes.
If you have to be there just to also safeguard HBEU's interests, does it then would seem not to be such an inconvenience to be part of the trial?
Yes. Justice Rogers, there are a number of counterfactuals built into your question. But if the question to me is it a great inconvenience to my client if it has to sit through the trial, having me represent HBUS and rather than HBU, the answer is no.
Or both?
Yeah.
Yes.
Or both, but presumably, well.
Can you just remind me, what is the position under the Competition Act in respect of costs against the Commission? If the Commission is found, that this might not affect your only client, but the Commission's deponent in the referral affidavit says that he verily believes all the facts in his affidavit to be true.
Yes.
So he verily believes certain facts about the employment, he verily believes that Brown Rig traded.
Yes.
Wasn't, for example, for Standard Bank. If it emerges at the end of a trial that none of that sticks and that the allegations were made recklessly, can the Commission have costs awarded against it? And might that also be so in respect of your client? If you have to sit through a 6-month trial only for it to be conceded at the end of the case that the Commission never had any basis to allege that Hatton was authorized to trade on behalf of your client, would you be entitled to get your costs against the Commission?
Justice
Frivolous or reckless litigation?
I'm answering off the hoof. I just can't find the relevant section. But, in fact, let me not answer on the hoof. Let me give you the relevant section, if I may. Justice Rogers, I don't want to waste your time. My recollection is there's a hard rule that prohibits costs against the Commission in the tribunal. That's my recollection. It's different on appeal, but there's a hard rule that prohibits costs in the event of the
So it becomes all the more.
Yeah.
It becomes a matter of the healing balm of costs, as somebody was wont to say, is not available to a respondent in the tribunal.
Yes, and when I say it's a hard. it's a hard rule. It's a hard rule which doesn't permit an exception, even in the case where the Commission has been recalcitrant or has been dilatory in the way in which it's performed its investigative functions. So it's furthering your point, Justice Rogers. If my client can't get the healing balm of cost, he's going to have to sit through the hearing without the prospect of recovering costs against the Commission in due course. And that's my recollection of the rule, Justice Rogers. If I've got it wrong, I'll do my best to correct it. But the last time I looked at that, it was an exclusion which had hard edges. There were no furry edges to the rule about costs.
There's, we directed that the parties wouldn't go into the question of simultaneous appeals and reviews, and I'm not sure, I suspect your client isn't one of those that brought a review. No. But, for example, the making of allegations for which there is no foundation, even if they pass the pleading muster,
yes,
might be a separate basis for a review.
Yes.
To prevent a litigant, I know Standard Bank has a pending review.
Yes.
That might be a way of addressing allegations for which there is no foundation and which weren't investigated.
Yes, yes. Yes, it may be. We didn't consider a review, Justice Rogers.
Yes. Thank you.
Sorry, Justice Rogers, the section I was battling to find is section 57 of the Competition Act. Do you have it, Justice Rogers?
The Act.
Of the Act?
Yes.
Competition Act. Section 57(1), subject to subsection 2 and the Competition Tribunal's rules of procedures, each party participating in a hearing must bear its own costs. And to the best of my recollection, the exceptions in subsection 2 don't assist. So the hard rule is each party bears its own cost in the Competition Tribunal.
Thank you. Thank you.
Thank you.
Mr. Cockrell, just coming back to this duly authorized point, in Northview Shopping Centre, the SCA said, if you plead at exception stage that the person is duly authorized, that's adequate. Then says, you could still raise authority in your plea, you could deny authority, and you've got to specifically plead it because it's a specific, it's a special defense, denying authority.
Yes.
Now you say that's not adequate for competition law. It may be good law for normal civil cases, but not for competition law cases. Is there any authority that says that for competition law, even though these two rules read exactly the same, 18.4 and 15.2, is there any authority that for competition law cases you must do more than just deny authority? Or put it differently, that for competition law, you must go further than you would do for ordinary civil cases?
There's no authority of which I'm aware, Justice Majid. The only authority that's come closest to it in our respectful submission is the Soweto City Council case. So in that case, I understand the facts were different, but in that case, even it was the High Court, not the SCA, so I accept the SCA ruling would take precedence.
Sorry to interrupt you, but isn't there a further problem? It's an ordinary civil case, it's not a competition case.
Yes, no, it certainly is. It's an ordinary civil case, but we respectfully submit that the same reasoning would apply. So nothing turns on whether it's a competition matter for this particular submissions. And what the court said in that case is, it's a factual question whether a particular person holds any specific authority. It may be proved in the same way as any other fact. So we would say the Commission makes the averment, the Commission now has to offer some credible basis for that averment, and that's what they haven't done. I understand that we are at the exception stage in inverted commas. I understand that we aren't at the trial stage. But with respect, the same reasoning should apply in our submission. The Commission makes the averment. I would be surprised, let me put it no higher than that, I would be surprised if the Commission has any basis for making the averment that Hatton was authorized by HBU. And now the Commission says, not my problem, it's a problem for some later stage. It just...
But as I understand it from what Mr. Ngatobi told us earlier, ESCOM was a case which concerned the authority of somebody to bring an application. In other words, it moved beyond the preliminary stage, if I may call it that. It was actually an application now in court, and that deponent to the affidavit's authority to bring the application as opposed to making an affidavit was challenged. So isn't it a big difference that we're now at exception stage here?
It certainly is different. I accept that, Justice Majid. What I would say is the averment is made by the Commission, authority of Hatton, and for similar reasons of underlying principle, in competition matters at any rate, the Commission should have some basis for making that averment, and if not, my client shouldn't be made to sit through the trial procedure.
Thank you, CJ.
Mr. Wade, Advocate Cockrell.
Thank you.
Thank you very much.
Thank you.
We now move to the Credit Suisse appeal. Advocate Norton.
Thank you, Deputy Chief Justice, Justices of the Court. The key issues that arise in Credit Suisse Securities application are first, whether the Commission has pleaded sufficient facts to establish that the tribunal has jurisdiction over it as a foreign peregrinus, and second, whether the Commission has initiated a complaint against it in accordance with Section 49B of the Competition Act. The jurisdiction ground of appeal arises from an error made by the appeal court in determining whether the Commission's pleadings establish the tribunal's personal jurisdiction over Credit Suisse. As we have heard, the Commission in its referral divides the respondents into three groups. First, what it calls the South African respondents, the South African banks. Secondly, the local Peregrini respondents, foreign banks alleged to have a presence in South Africa. And third, the foreign Peregrini, foreign banks not alleged to have any presence in South Africa. The Commission pleads in its affidavit, in its amended referral at paragraph 4911, that Credit Suisse is a foreign peregrinus. That is also common cause in the Commission's application to join Credit Suisse to the referral. In the first round of interlocutory proceedings in this matter, the tribunal found that the Commission had alleged sufficient facts to establish the tribunal's jurisdiction over 7 local peregrini, and the appeal court did not disturb that finding. In respect of the foreign peregrini, the appeal court held that personal jurisdiction must be established in accordance with the connecting factors test. Now, when this matter reached the appeal court in the second round, the appeal court considered whether the Commission, on the new case now pleaded in its amended referral, had pleaded sufficient facts to satisfy the connecting factors test. It held that in the case of foreign peregrini not alleged to have been part of a conspiracy in which they participated with South African banks directly, the Commission had failed to plead sufficient connecting factors. There were 3 foreign peregrini who fell into this category: the 19th respondent, H-Bus, the 20th respondent, Merrill Lynch, and Credit Suisse. Each of these respondents is alleged to have had interactions only with foreign banks, and indeed with the same foreign banks. None of these respondents is alleged to have had any contact with any of the South African banks. The 3 respondents, Justices, are similarly situated in every key respect. The appeal court held that the Commission had failed to plead sufficient connecting factors in respect of Merrill Lynch and H-Bus because it had not pleaded facts to connect them with any South African banks. But when it came to Credit Suisse, the court took a critical misstep. It said at paragraph 139 of its judgment, CSS is a local peregrinus and only subject matter jurisdiction is required in this case. But Credit Suisse is a foreign peregrinus, and the tribunal's jurisdiction over it should have been determined on the same test that was applied to Merrill Lynch and H-Bus. The court would then have found that the Commission has not alleged any interactions between Credit Suisse and any of the South African banks, and has failed to plead sufficient facts to establish the tribunal's jurisdiction over Credit Suisse. We say this was a patent error by the appeal court. Now, the Commission, in response, does not dispute that Credit Suisse was wrongly treated as a local peregrinus, or that the appeal court would have upheld Credit Suisse's appeal if it had treated it as a foreign peregrinus. Instead, it resists this appeal on three alternative grounds. The first is that the jurisdiction requirements determined in the first appeal court decision were wrong, but that, of course, is to resurrect an issue that was determined by the appeal court in the first round. And for all the reasons that we've set out in our written submissions, we say that the jurisdictional requirements applicable to foreign peregrini are therefore res judicata. But if the Commission is permitted a rerun of its Section 3.1 argument, we submit that that argument is in any event unfounded. Section 3.1 gives the Act a broad scope of application, but the tribunal's jurisdiction must be determined in the light of all the relevant provisions and principles. And here the connecting factors test adopted by the appeal court achieves at least two objectives that Section 3.1 on its own cannot. The first, by requiring the tribunal to consider whether it is the appropriate forum, it ensures that the tribunal will exercise the necessary moderation and restraint in cases having a foreign element. This was something, a consideration identified by the Competition Appeal Court in the Anzac matter. And so comply with considerations of comity, which, as this court recognized in the case of South African Human Rights Commission versus Standard Bank of South Africa, may dictate that a matter is best left for adjudication by a foreign court that has a closer connection to the matter. One might consider if this case had in fact involved only the foreign firms said to have been involved in the old Gits chat room in New York. One would have wanted the tribunal to ask itself, if we have firms and conduct in a chat room in New York involving conduct regarding the US dollar South African rand currency pair, and in circumstances where the New York authorities have taken steps to prosecute the very same conduct, is this the appropriate forum? And that, we say, the connecting factors test does, because the first step is to consider with moderation and restraint the question of appropriateness. Second, the connecting factors test ensures that the tribunal's orders would at least be capable of enforcement by the High Court, because the test is consistent with the requirements governing the High Court's own jurisdiction over foreign peregrini, the test laid down in Strang, which has indeed been followed ever since. The test therefore promotes the effectiveness that's foundational to the rule of law, although it must be borne in mind here that what is envisaged by the principle of effectiveness is not that a court or a tribunal can in fact make an order effective against a particular respondent, even a respondent which is an insular in a particular jurisdiction, but that the order is at least capable of being enforced. The Commission's second contention is that if it is bound by the connecting factors test laid down by the appeal court in its first decision, it was not required to plead direct contact between foreign peregrini and South African banks. But the appeal court did not dream up this requirement. It arises from the Commission's own pleading in the amended referral. The Commission, we've seen this before, pleads in paragraph 50 that the tribunal has personal jurisdiction over the foreign peregrini by virtue of two connecting factors, the second one being that they participated in a conspiracy together with the South African respondents. Now, it did so because it had told the appeal court in the first appeal court proceedings that it was not prosecuting separate cartels, some involving only foreign banks, but an SOC involving South African banks. Thus, it had in its pleading net banks and conduct that was squarely within the tribunal's territorial jurisdiction, and it needed to pull the foreign banks into an SOC with those banks. This it could not do by relying only on the involvement of the South African rand. Having pleaded that the respondents were in a conspiracy together with the South African respondents, the Commission was then required to plead facts from which it could be established or plausibly inferred either that the foreign peregrinus had direct contact with South African respondents, or it had actual or imputed knowledge that it was participating in a conspiracy that involved the South African respondents. We say that's the very least that was required on its own pleading. It's also what is required to establish its cause of action, in line with all the jurisprudence on single overarching conspiracies that it relies on. But the Commission has not pleaded any facts that would support either proposition in respect of Credit Suisse. It pleaded 8 conversations with the traders of 4 foreign banks. The Commission's third line of defence is to contend that Credit Suisse was connected to the South African banks through its connection with Mr. Katz, but the Commission has not pleaded any facts from which it could be plausibly inferred that Mr. Katz connected Credit Suisse to the South African banks. The final string to the Commission's bow is a late-in-the-day suggestion that the direct contacts requirement is met by its averments that Credit Suisse's representatives had interactions with respondent banks that are local peregrini. But, Deputy Chief Justice, the presence of a branch office in South Africa, which is not alleged to be implicated in the conduct of the SOC, does not render a non-resident bank a South African participant in the SOC. Deputy Chief Justice, we submit that the Appeal Court ought to have found that the Commission has failed to plead sufficient facts to establish the Tribunal's jurisdiction over Credit Suisse. We say that the issues raised by this ground of appeal fall squarely within this Court's jurisdiction. The Appeal Court's failure to treat Credit Suisse as a foreign peregrinus resulted in its application of the wrong legal test to determine personal jurisdiction, and it resulted in Credit Suisse being treated differently to other respondents in exactly the same position. We submit that the Appeal Court acted contrary to its duties under the rule of law, under Section 34(1) of the Constitution and Section 9(1) of the Constitution, first to give proper consideration to the issues and facts before it, and secondly, to apply the law consistently and uniformly, and to apply the same laws without discrimination to all persons who are similarly situated. We refer the Court in this regard both to its recent decision in Vodacom versus McCarthy, and also to the decision of this Court in Metcash, referred to earlier by Justice Majid. And there we draw the Court's attention to the paragraphs 18 and 25 of that judgment, where a couple of points were made which made it clear that Metcash did not close the door to an argument before the Court that in this instances the respondents were entitled to be treated alike. There, the Court held that was dealing with 2 different panels, determining reasonable prospects of success on appeal, exercising a discretion where the Court said different panels could reasonably come to a different conclusion. But in paragraph 18, left the door open to say that even in that situation where you were dealing with different panels and not the same decision maker, if the difference in treatment was based on irrational or arbitrary decision making, it might lead to a different result. We also say that the interests of justice favour the hearing of this appeal, and we have covered those in our written submissions. I'm going to deal very shortly with our initiation ground of appeal. The Commission applied to join Credit Suisse only after the original referral. It was joined after the amended referral. Whether that was competent has been addressed by other counsel. The issue raised by Credit Suisse's appeal is what this court decided in Pickford's. Did it decide, as the Commission argues, that once the Commission has initiated a complaint in respect of prohibited conduct, it can refer a complaint to the tribunal against any firm alleged to have participated in that conduct without first adding that firm to the complaint initiated, whether formally, informally, expressly, or tacitly. And we say that this court in paragraph 21 of Pickford's recognized expressly that the initial omission of a firm at a stage when the complaint is first initiated and its subsequent addition to the complaint are not fatal. That's not what happened here, and for those reasons we also submit that Credit Suisse has not been valid, there's been no valid initiation of a complaint against Credit Suisse.
Thank you, Advocate Norton. Any questions?
Ms. Norton, you may have dealt with this, but I didn't get it. On the one criticism is that the initiation was not proper against your client. And you also submit that the pleading was required to provide that it was in contact with South African banks.
That's correct, Justice.
I'm asking that I would like us to focus on 138 of the CAC judgment. And all I want to ask is whether the way it captures your submission and the response that it gives, whether you've got comment on that.
Justice Cheeky, paragraph 138
Paragraph 138
of the
first three sentences.
the first Competition Appeal Court judgment, or the second?
The second one.
The second. Okay. 38. Okay.
I printed the judgment, so I'm not able to assist you with where to find it in the record.
CSS's counsel submitted that the Commission case illustrates that it was predominantly in communication with Peregrini banks. That's, yes, Justice Cheeky, I see where you are. However, Barclays Capital was also in the old GITS chat room. Evidence suggests that the representatives of Barclays and Citibanks, which are local Peregrini, were also present in the chat room. Standard Chartered also had an agreement with the Commission. It too had an office in South Africa.
Yes.
Justice Cheeky, what the court appears to have been saying there is, you've come and told us that you were just in a chat room with foreign banks.
Yes.
Actually, those foreign banks also had offices in South Africa. And we submit that is not sufficient basis on which to draw any link between Credit Suisse or any other of the parties in the old GITS chat room with the South African respondents, because remember what the Commission pleaded was participation in a conspiracy with the South African respondents, and the Commission itself identified what it meant by that term, the South African respondents, early in its pleadings, and it was the 8 South African banks. Links with foreign banks which happen to have a representative office in South Africa, which are not implicated in the trading at all, we say are irrelevant to the issue.
Okay, thank you, I understand now. And then the other one point that I would like you to respond to is 139, concerning the intensity of Hatton's involvement in the chat room. That's one of the factors that the CAC seemed to find against you.
Yes, Justice, thank you for that question. Our point is not whether or not there was intense involvement in the chat room by Credit Suisse's traders, alleged traders. Our point is that in order to tie Credit Suisse into the SOC pleaded by the Commission, in other words, an SOC in which it participated with South African respondents, those relevant facts have simply not been pleaded. And so we don't begin to look at whether there are sufficient, we don't begin to look at questions of participation, the intensity of participation. We accept that the Commission has pleaded sufficient facts to establish that Credit Suisse had traders in the old GITS chat room. But the point that we argue before you, as I said earlier, this is not a case where the Commission, and it's interesting to imagine if this were a case where the Commission actually was just prosecuting the participants of the old GITS chat room before you today. This is not that case. And this is a case in which, and we say that the Commission would likely have been turned back at an early stage on the basis that there simply wasn't a link. Insofar as it relies on the South African rand, that wouldn't have been enough. Because, in fact, we know that the New York authorities prosecuted the conduct in the old GITS chat room involving the South African rand US dollar pair, currency pair.
Thank you.
Thank you, Justice.
Ms. Norton, should we also understand your submissions to be your client should have been treated similarly to HBC USA and MLPFS?
Insofar as the Competition Appeal Court found that if you're a foreign peregrinus,
Yes.
the Commission had to show connections to South African banks, and it didn't even apply that test to us because it made a mistaken assumption. It didn't have proper regard to what the Commission had pleaded, which was that Credit Suisse is a foreign peregrinus.
Yes. But I think what the questions Justice Chike put to you tell us what the CAC's reasoning was as to deciding differently as far as your client is concerned.
Well, it's not easy to follow, Deputy Chief Justice, because the CAC had said that it didn't need to apply to us the test that it applied to foreign peregrini. It then seemed to want to address a submission that had been made in the written submissions before it. And the submission was actually that Credit Suisse's traders in the old GITS chat room were alleged only to have been in discussions with American firms. And what the appeal court then wished to point out, and we say that nothing turns on it because they wanted to point out that some of these foreign firms had branches in South Africa. It's not clear what the purpose of adding that, what the court's purpose was in adding that rider. But in it, particularly because the other respondents, HBUS and Merrill Lynch, were once again similarly situated. They'd also had chats with the very same banks that had offices in South Africa. So, as I said earlier on, these three banks are similarly situated in all material respects. And it was just by overlooking, disregarding the pleading of the Commission that Credit Suisse was treated differently.
Thank you for that. Oh, wait, okay. Rogers, you don't have a question?
Mr. Norton, the argument that you advance is that the problem arose when your client was classified incorrectly, correct? And it seems that that incorrect classification may have had its foundation in the referral affidavit of the Commission. That
Sorry, no, Justice Collipin. The Commission had pleaded that Credit Suisse is a foreign peregrinus. The court didn't have regard to that and mistakenly treated Credit Suisse as a local peregrinus.
well, in the affidavit at paragraph 46, it says the second class of local peregrini are the 11th respondent Credit Suisse.
That's a different entity, Justice Collipin. That's the Credit Suisse group entity,
Okay.
which was part of the last proceedings, but not part of these.
Then my question is that in the judgment at 138 and 139, and you've dealt with that, the suggestion seems to be that your client's representative was party to chats with banks other than American banks, not so. That it extended beyond that.
No, Justice Collipin. Once again, the suggestion seems to be we the same chats, but now because the people that Credit Suisse, the banks that Credit Suisse was, the foreign banks that Credit Suisse was interacting with, also had some of them had a branch office or a representative office in South Africa, that those banks could no longer be regarded as foreign banks.
Yes. And you say that would not be sufficient in terms of the test that they would have had to apply, because you're saying they applied the incorrect test because they classified them incorrectly.
The appeal court didn't even begin to apply the test to Credit Suisse because it proceeded from a wrong assumption.
And so if it was other banks in South Africa, that would fall short because it would have to be South African banks in accordance with the connecting factors test.
And in accordance with the Commission's pleadings as to who the South African respondents were that it refers to.
Thank you.
Okay, that seems to be it. Thank you, Advocate Norton. I think we're going to take the lunch adjournment now. We're going to adjourn for 30 minutes, and then we'll come back. Thank you very much. Court adjourns. Advocate Mukaitobi, please go ahead.
Thank you, Deputy Chief Justice. I want to deal then with the first submission about the error of fact and the consequences that it might have. And then I will also deal with initiation. Let me start with the error of fact. It is correct and self-evident that the statement made by the CAC that at paragraph 139, that Credit Suisse Securities, that's the US-based, is a local peregrinus, is inaccurate. And it is an error that is inexcusable in these days of Makate. But it is, as a matter of law, an irrelevant error because the conclusion that Credit Suisse Securities should have been added is correct. And so in the discussion we had earlier with Justice Rogers about the focus of the appeal being on the order is unimpeachable. Also, the reasons that are given are equally unimpeachable. Because if you look at the actual reason, and it is at page 281, starting at paragraph 138, the judge says, CSS's counsel submitted that in the case of CSS, the Commission's case illustrates that it was predominantly in communication with peregrine banks, being Bank of America, Citibank, Standard Chartered, Merrill Lynch. However, Barclays Capital was also in the old JIT's chat room. The evidence suggests that the representative of Barclays and Citibank, which conducts the business of a bank in South Africa through a branch, and which reached an agreement with the Commission confirmed in an order of 26 April 2017, was also present in the chat room. Standard Chartered also reached an agreement with the Commission. It too had an office in South Africa. For these reasons, it is incorrect to suggest that the case brought against CSS was that it was party to chats in the chat room only with American banks. And then the error then is introduced there. But the way that error is introduced is also vital to remember. It says in addition. So it's an additional reason. It's not the sole reason. It's an additional reason. But it also plays no role in the order, because at least reason number one, which is the fact that you are in a chat room with banks that had South African presence, is decisive and enough. So therefore, we say that although it is an inexcusable error, it is an irrelevant error. We support that independently in any event. We support the conclusion independently in any event for our own reasons. First, Hatton is one of the most prolific players in the scheme of manipulation. You've heard me several times talking about Hatton. I'm not going to expatiate any further. Secondly, this communication is in the old GITS. And it is correct that in the old GITS there are banks with South African presence. It's just important to recap what that means. Bank 1, that was in old GITS, at some point represented by CATS, is BNP. Now, BNP has a registered branch, but it is also authorized to deal in Forex in South Africa. That is at paragraph 12 and 44 of the referral. That's the first bank, BNP. So he's sitting there with those South Africans. Then the second bank is Citibank, which is also in old GITS. It also has a registered. It is also authorized to deal in Forex. The third bank is HSBC, HBU, I think the 14th respondent, because these HSBC entities have different names. It too has a registered branch, which is also authorized to deal in Forex. And then you have the Bank of America National Association, which also has a representative office, also authorized to deal in Forex. Then you have Standard Chartered, also a registered branch, also authorized to deal in Forex. Outside of these four that have registered branches that are authorized to deal in Forex, you also have representative offices in South Africa. Now, the case made by the Commission has been variously construed and misconstrued. But paragraph 50 simply says that the foreign banks were involved in a conspiracy with South African respondents. It does not mean each foreign bank must have had communication with a South African bank. It means in the overall conspiracy, there were South African respondents. And it also doesn't mean that the conspiracy is confined to the Old Gates chat room. The conspiracy goes further than the Old Gates chat room. It includes the ZAR, it includes other chat rooms, it includes private communication, telephone discussions, and trading data. Now, in that SOC, there were South African banks. We know of ABSA, Nedbank, that have actually applied, ABSA has applied for leniency, and Nedbank hasn't. Now, this is the case that is made out, that when you look at the SOC as a whole, it had South African connections. But it is a very strong consideration when one is looking for adequate connecting factors, that these traders in the old GITS had South African branches authorized to carry out the business of banking, but also authorized to deal in Forex. And that is why the conclusion in paragraph 138 of the judgment is actually unimpeachable, notwithstanding the unfortunate error. So therefore, it is clear that Credit Suisse Securities was correctly categorized as being part and parcel of the SOC, but it was also correctly categorized as being one of the banks over whom our authorities have jurisdiction. The only way they get out is by an artificial interpretation of paragraph 50 of the referral and a grave distortion of the law. And that distortion of the law assumes that the way to establish connecting factors is to find foreign banks in individual communication with local traders, which is not the law. The law is, we've discussed already. So when you apply the correct legal standard, the inevitable outcome is that Standard Securities is, Credit Suisse Securities was correctly added and there's jurisdiction over them. Then you go to the second topic, initiation. Now, this is different to the other banks, and we just need to clarify why it's different. If I can take the court to volume 6, page 487. At paragraph 2.3.3. There is an express initiation there. That's now the amended initiation. There is an express initiation against Credit Suisse, which is described as a company incorporated and registered under the company laws of Switzerland, with its principal place of business in Zurich. Okay? Now, what their case is sorry, our client is the US company of Credit Suisse. That is their case. Now, of course, what would have happened is so clear. Charts are disclosed, Credit Suisse is mentioned. The Commission then initiates against the Zurich-based company because it does not know of the United States company. Now we go back then to Woodlands. Perhaps before we go to Woodlands, there's actually something interesting in the initiation document itself. The initiation document actually makes it clear if you go to page 484, paragraph 1.5, that it's based on the information in the possession of the Commission at that stage, because it says, furthermore, the information indicates that the respondents in the original complaint, that's the one of April 2015, and the respondents in the amended complaint may have engaged in market division by allocating customers in possible contravention of the Act. The information indicates that the above conduct may have commenced around 2007 and may be ongoing. So that makes it clear that at that stage, they're talking about what they know. But what is unmistakable is that Credit Suisse, the Switzerland company, is expressly initiated against. Now, on Woodlands, what you need to ask yourself is whether on these facts, generously construed, you cannot come to the conclusion that there was no tacit initiation against the correct branch, which is the US, which did the actual trading. So this would then be the most perfect example to apply
Suisse Group was added to the initiation of 1 April 2015. Now, the notion of what is tacit goes to what is in your mind and what is intended but not expressed. And if the Commissioner on the 1st of April 2015 had in mind that all the banks that might ever be drawn into this SOC were now part of this initiation, there would have been no need for an amended initiation, a formal express amended initiation a short while later. And then in a final submission, this court is told that actually you can take the amended initiation, and on the facts generously construed, you will find that that was the tacit initiation against Credit Suisse securities, that in the second amended initiation, there was now a tacit initiation against other entities related to the Credit Suisse group. And we submit that those submissions are at war with one another, and ultimately what we have in this instance is a party against which there has been no initiation whatsoever. Thank you, Deputy Chief Justice.
Thank you, Ms. Norton. Any questions? Appears there are no questions for you. Thank you very much.
Thank you.
Thank you. Mr. Campbell, you are in the BNP Paribas appeal.
That is so, Deputy Chief Justice.
You may go ahead.
Thank you. Deputy Chief Justice, if I opened my submissions with the observation that the curtain raisers had now been played and it was time for the main game, justices of this court might, with every justification, think that I had taken leave of my senses and parted company with reality, because this application is, of course, by some distance, the narrowest and the shortest of everything that you've heard before. But that would be a fraction of the parting of reality that the Commission has undertaken in their submissions, which we'll get to shortly. Before we do, I just want to start with my grounds of exception, which of course are vague and embarrassing. And I start that, Deputy Chief Justice, paragraph 1 of my exception, where I simply set out the extracts of the pleadings that we say are vague and embarrassing and confusing. For completeness, that is at page 739 of the record. And the first one is that the Commission pleads a single overarching conspiracy between 2007 and 2013. The next version, so they tighten slightly, is with effect from September 2007 until at least September 2013. And I would ask justices to note that the words at least, of course, open that up. We don't really have an end point. But now the fun starts with the third extract. And that is, and I'm quoting, "The Commission does not know the date on which the single overarching conspiracy between the respondent banks ceased to operate, or if it has indeed ceased to operate." The fourth iteration is even more confusing. The Commission alleges that the conspiracy continued to operate using different modes of communication after September 2013, alternatively, after the implicated chat rooms were closed, further alternatively, after the respondents' traders no longer had access to the Bloomberg electronic messaging system. And I want to make it plain that we have no difficulty with the alternatives. It's the entire submission there. And the fifth is that the Commission does not know the date on which the overarching conspiracy between the respondent banks ceased to operate. That's similar to the third, but then they add another phrase, if it has indeed ceased to operate. So they leave that open. Now, Deputy Chief Justice, the test, of course, in exception, is that we must accept that every allegation made in the referral is true and correct. That's the basis on which we judge the exception. So it is both true that the Commission does not know the date on which the single overarching conspiracy between the respondent banks ceased, and it is also true that it continued only until September 2013. And I have to ask the question as to why, if you don't know the date on which the overarching conspiracy ceased, then on what basis are you pleading that it lasted until at least September 2013? One of those allegations is plainly not true. Equally, you can't then, at the same time as you say you don't know the date on which it ceased, you can't allege that it continues to operate after September 13, which is the import of both the fourth iteration and the second. And you also then can't question the fact if it has indeed ceased to operate. Now, before I move on, I want to make a distinction between two different concepts, because in both the Competition Appeal Court judgment and in the Commission's heads of argument, they attempt to set up the wrong set of skittles to knock down. So I want to make it clear, our complaint is not that we don't understand the substance of the case made against us. In other words, we are not looking and saying we don't understand what Katz was doing, we deny that Katz did this, whatever. That is not our case. Our complaint is only that we do not understand on what date the collusion involving us is alleged to end. So, the contradictions, I think, are obvious, and I want to now just briefly have a look at what the Commission says about them, and I want to start with their heads of argument at page 42 of the heads bundle, and paragraphs 1.3 and 1.4. Now, modesty, of course, prevents me from reading out 1.2. But paragraph 1.3 correctly sets out the grounds of exception. Then 1.4 says that BNP is the only respondent which takes material issue with the cessation date. Now that is a factually incorrect submission, because two others, at least two others do, and I'll give you two references. Bank of America, at paragraph 76.4 to 76.6 and 97 of their heads of argument, and Namira at paragraphs 34.2 to 34.4 take precisely the same objection. So it is not correct to say that we are the only respondent who does that. Thereafter, can I move to paragraph 5? And here, the Commission makes, for some reason, the submission that Katz is alleged to have engaged in the full range of conduct forming part of the SOC. Of course, it's common cause that Katz was employed by BNP Paribas for a reasonable length of time. And they then set out in 5.1 to 5.7 various examples. But what of it? What complaint does this answer? This answers the complaint that we didn't make, not the complaint that we did make. And they cannot answer the complaint that we did make by referring to Katz's involvement. That's got nothing to do with the end date. I then want to go to paragraph 6, and again, we get the general allegations. Overall, Katz is directly implicated in at least 67 instances. Got nothing to do with the complaint that we've said. Doesn't answer anything, not a single thing. And then I want to go to page 48, and I want to deal briefly with this tired formulation which we see in footnote 30, where I think there's an attempt to characterize what we say as formalism and technicality. That is, of course, always what people do when faced with the implications of inaccurate pleading. And I would simply submit that requiring them to plead the end date is not formalistic, it's not technical, it's really just doing no more than to ask them to comply with CAC 1, which I'll come to in due course. And then on page 50, on paragraph 11, they say the referral sets out the Commission's case in respect of cessation of the SOC, and then they continue to say, on a proper read, is consistent and not contradictory. But I think I've demonstrated that if you have no knowledge of when the end date is, then it is impossible, it is logically impossible to plead that the end date was September 2013. So I'm utterly mystified. I've never quite seen a submission in argument that is so squarely 180 degrees wrong. Then they go on to say that the SOC is alleged to continue until at least September 2013. But in case we've forgotten, they say at the end of the paragraph, it is then also clear that the Commission doesn't know the date. So even in their own submission, they highlight their contradiction while denying that there's a contradiction. And then on page 51, there is a reliance, on page 51, footnote 44, there's a reliance on the Nell versus Welkovich case. Now that is, I think, in support of a submission that an exception had failed, an exception taking the point that the plaintiff had pleaded that at an unknown time and date, a medical practitioner had become involved in attending to the deceased. Now, what that was a medical negligence suit, the patient who had died. And the issue was whether a duty of care had been acquired by the doctor treating her. And the defendant took the point, well, you never mentioned the beginning date, the date when she started. The court then found, you'll see that my learned friends rely on paragraph 29, but I would urge justices of this court to have a look at paragraph 20, where the judge hearing this application says, a formal doctor-patient relationship is not a necessity. In other words, she finds the missing fact was not necessary. That's why this exception was lost. And then briefly over the page to paragraph 16, where it is said of us that we want the referral to limit to one particular alleged end date. Yes, we do. And other cessation dates pleaded in the alternative or in an open-ended basis. As far as the alternatives go in the fifth option, we don't mind, but they're all internal in the fifth option. And then I want to move briefly to the judgment of the Competition Appeal Court. And that will be, I think, at page 224 of the record. And I want to go to paragraph 151. And I want to make the following observations. In the last sentence, concluding his reasons as to why he's dismissing the application, the Competition Appeal Court says, since the averment is that the SOC ended in 2013 and that Mr. Katz was employed until that date. No, that's not the averment. It's one of 5 averments. It's quite wrong for the CAC to say that's the averment as if that was the only one. Because obviously when you read that, it does look as if there were no alternatives. And then he says, and that Mr. Katz was employed until that date. That's also an argument advanced by the Commission. And may I just say this, that if they wish to tie our term, as it were, in the prohibited practice to Katz employment, just plead it. Recorded involvement in the referral is on the 18th of October 2012. But if you want to tie our involvement to Mr. Katz, then say so. The mere fact that it is said that you can do that means that's fine. Then, really just in the last 2 3/4 minutes, there's no real defence to this. I suppose the closest that the Commission comes to mounting a coherent and a logical defence is to say that it's not appealable. And on that, for that proposition, they rely on TWK and similar cases. The distinction there is TWK involved the dismissal of an exception that went to the true full merits of the case. In other words, something that could be argued. Our exception is final in effect, and that is why it is different from TWK. It is final, Justices, because we will have no opportunity between now and judgment in the tribunal to patch it up or to get a better order. Once we plead, it's over, and we will simply be saddled with the fact that we have to do the best we can, which won't be very well, with a completely inconsistent and illogical end of term date. So there is no, apart from this forum, there is no other court, there is no court at all that can assist us, and the tribunal certainly won't be able to assist us at all. When it comes to pleading, Justice, one is required to respond to an allegation in one of three ways. You admit it, you deny it, you confess and avoid. You can't plead to referral by saying, this is vague and embarrassing, because after that, what does one do? And if one accepts that all the allegations are true, including both that they don't know the date and that there is a date, one just doesn't know what to do. So we say that the prospects of success are very high. There is nothing in the interest of justice that suggests that it shouldn't be granted. It is clearly appealable because it is final in effect, and we'll be saddled with this disability, as it were, the entire time. And I'm happy to say that I'm coming home 35 seconds in time. Thank you, Justice. If there are any questions, I'll be happy to take.
Thank you very much, Mr. Campbell. Am I correct, because you've pointed to several iterations of the complaint against your clients, but the nub of it all is it relates to the end date of the SOC?
That's all we do. That's all we do. It's our only complaint.
In the context of this case where the SOC is set to go through a particular period, and on your point, you don't know what the period is, because we've got different versions of it. Is it not so that, because the Commission's case is linked to Mr. Katz, isn't it?
Large part, but I don't find to Mr. Katz.
As a major player in this SOC, and Mr. Katz has had links with you. Is it unreasonable, or was it unreasonable for the CAC to rule that you must know what case you've got to answer when you bring in Mr. Katz's activities in this whole case, without focusing on just the end date?
Deputy Chief Justice, that's the distinction that we made. The mere fact that Katz is employed by us and he is alleged to be involved doesn't tell us anything about when our involvement in the conspiracy, because of course Katz left our employment as well. He joined us halfway through, or two-thirds of the way through, and left us as well. So, as I say, if they want to tie our involvement to the period in which we employed Katz, plead it. It's not difficult. And if I may add to that, the Commission has an enormous amount of information. Certainly it was clear from the first referral that they had access to the American proceedings and the American information. Since then, they've had at least one leniency applicant. They've settled with others. All of those parties that applied for leniency and settled were in a position to give them information. There's just absolutely no excuse for not settling on a date. And even if they find out later that it actually extended slightly further than the date they settled on, they can amend. And they'll be granted that amendment because they say we found this information only after we had pleaded. Of course they can do that. Anybody can amend. I can't see any excuse for not pleading a coherent end date. And I've tried to look.
Thank you, Mr. Campbell.
Mr. Campbell, still a follow-up on this question. We know that from the papers, Mr. Katz was employed by BNP from 2011 to 2013.
Yeah.
And para 56 of the referral affidavit, it says this SOC took from September 07 until September 2013. What is confusing for the applicant in this matter?
The confusion is that is contradicted elsewhere in the referral. If one takes each paragraph in the referral and atomizes it and seals it, it's not confusing. But we've got to read the referral as a whole. One of the ways one decides exceptions, of course, is to look at the pleading as a whole. But in any case, even when we plead, we look at the pleading as a whole. And they contradict themselves. They cannot say in one paragraph that they don't know when it ended, and then say in another paragraph that it ended in September 13, and then say in another paragraph that they aren't even bound by that. It could be even sometime further in the future.
Why can't the applicant plead? Because the number of allegations against Katz, some in 2011, some in 2012, why can't, and at that time, we know that Katz was in the employ of the applicant. Why can't the applicant then respond to those allegations?
The applicant can respond to allegations, but the applicant can't respond to the contradictory allegations concerning the end of the SOC, because they are contradictory. So yes, there is stuff that we can do, but again, that's the distinction that I made at the beginning. Our complaint isn't that we don't understand the broad thrust of the case against us. Our complaint is that we don't know where to stop investigating and looking for documents and discovery, all of these things that flow from knowing when the end point is. We all need to know that.
I would have thought that you would stop when the role player or the main player in this left your employ.
No, but the Commission specifically says, sorry, please take this away. The Commission specifically says that it does not stop with him. They specifically plead that.
Thank you, Mr.
Thank you.
Yes, Mr. Campbell, first on the question of appealability, the usual position is that the dismissal of an exception is not appealable. And that would apply both to an exception on the basis of no cause of action and on vague and embarrassing. Now, whenever in High Court proceedings a dismissal, an exception on the basis of vague and embarrassing is dismissed, the defendant then has to plead to the particulars of claim. There won't be a chance for that to be fixed up. Its prejudice, such as it is, in having to plead to something which it finds vague and embarrassing is something with which it just has to live. Why is it different here? This is also the dismissal of an exception on the basis of vagueness and embarrassment. You're in exactly the same position as you would be as a High Court defendant who's lost such an exception to particulars of claim.
Justice Rogers, there is certainly a practice that when people lose a vague and embarrassing, they accept that they were wrong in arguing that the pleading was vague and embarrassing.
I think that's a very wide assumption.
But we don't accept.
Have you ever come across an advocate who thought his argument was wrong?
Well, if I were to think about that, we might be here tomorrow morning. But the point is that more recently, the exception has become more sharp-edged. And in TWK, Unterhalter AJA was very clear in saying the reason why is finality. And if it has a final, if it doesn't have a final effect, but here it does have a final effect, and I'm not sure that anybody has ever given any proper consideration to it, certainly not in my experience.
As to the appealability of a vague and embarrassing exception?
As to the finality of it.
Well, it's final in the sense that unless a plaintiff of its own accord later amends its pleadings, you will have to plead to it.
Correct. And that takes it out of the TW category.
Well, so perhaps you're going to tell me on my second question, which was as to why this court has jurisdiction. You say we have to answer an important question of law as to whether the dismissal of a vague and embarrassing exception is appealable. But leaving aside the Commission's concession, which you rely upon in your submissions, if the appeal court wrongly thought that you were not faced with a vague and embarrassing referral, why does that error, if it is an error, engage our jurisdiction? I know I think in your written submissions you referred to the fact that the Commission is a public body and it concerns the exercise of its powers, but I assume if Transnet issues a summons that somebody says is vague and embarrassing, the defendant can't say that's a constitutional matter because Transnet's a public body.
Let me put it on two bases. First of all, there is the right to a fair trial, and a right to a fair trial must, if it means anything, mean that you know with precision the case that you have to face. That's the first one. The second thing, of course, is a rule of law issue, which I should, in fact, have recalled and raised in response to your earlier question, and that is that the pleading dishonours the order made in CAC 2, which directed them. So the other constitutional issue raised is the extent to which bodies bound by CAC 2 can depart from it. Now, you recall this morning, my learned friend who leads for the Commission was very clear that CAC 2, apart from the Section 3(1) point, is correct. Sorry, CAC 1, Justice Rogers.
Question whether the Commission did or did not comply with CAC 1 in regard to pleading the end date of the conspiracy and of your client's participation in it is tied up with the vagueness and embarrassment point, because the Commission says, well, it did plead those dates. And you say, well, we don't fully understand it, but you had your day in court on whether it was vague and embarrassing, and the CAC found against you.
It is tied up. It is tied up, yes.
So is it a question, is the Commission's opposition to your appeal based on an argument that CAC 2 was not bound by CAC 1 in that respect, or simply that they say they did comply with it?
I understood them to say that they have complied.
Yes, and the appeal court in the second round evidently agreed.
Yes. Well,
so the case isn't about.
I wouldn't go that far, to be honest. I wouldn't go to. They first of all mischaracterized the pleadings and said that passed muster. I wouldn't go quite as far as Justice Rogers as you did in that. On that.
Yes, thank you.
Campbell, can I just check with you? Just remind me, when was Mr. Katz employed by BNP? Just the years.
Starting in 2011 and ending in 2013.
So it covers the period. On any reading of this, what you say is a contradictory pleading referral.
Yes.
It's covered. So what's the problem? What case do you not know what
problem
meet?
The problem is perfectly simple. They've specifically pleaded that our involvement in the SOC extended beyond September 13, beyond 2013. That's the problem.
Because they say that this is something within your exclusive knowledge. But to the limited knowledge that they have, they say that at least until 2013, Mr. Katz was involved with you, but if the conspiracy ever ceased, it may have continued after 2013 through other modes other than the chat rooms. What's wrong with that kind of pleading at an exception stage?
Justice Mayet, the fact that I have knowledge in every single case, a defendant has knowledge of certain facts that a plaintiff doesn't. that doesn't absolve the plaintiff from pleading the full case and all the material facts with some precision. That's
Was the full case or material facts?
the first point. The second point is that if we are to be tied, I've got no objection to being tied to the 2-year CATS period, but could somebody then please plead it? And then we've got no problem. That's all they have to do. It's not a difficult thing to fix up. I'm frankly staggered that we're still here.
And just the last question. I was intrigued by this in volume 9 in your exception, page 740. I was intrigued by this paragraph 2.3. This is what you say. First, you say in 2.1, these allegations are vague and embarrassing because you refer to the incoherence about the end date. Then 2.2, these allegations are contradictory, cannot all be correct. 2.3, this is the one that I would like you to explain. The period of BNP's participation in the SOC is one of the determinants of the quantum of the penalty, and it is entitled to be in a position to assess its potential liability. We're at exception. It's very early days to assess your potential quantum. What relevance does it have to the exception?
I'm sorry, Justice Mayor, I've lost you.
I'm at page 740.
Okay.
Volume 9, you plead in 2 the basis for the exception. First, vague and embarrassing. 2, contradictory. 2.3, you say this: the period of BNP's participation in the SOC is one of the determinants of the quantum of the penalty and is entitled to be in a position to assess its potential liability. It's like a kid who steals fruit and says, listen, I'm not admitting my guilt, but just as a matter of interest, what potential penalty am I looking at? I don't understand that.
It's not. That's precisely what it's not asking or complaining about. It's saying, I would like to know the full period in respect of which I'm going to be held liable.
What's it got to do with the quantum of the penalty?
Because that is one of the determinants.
I say this tongue-in-cheek. You complain about the fact that they don't tell you when the SOC ended, but you're already anticipating your end, the sanction end, the penalty end, the quantum.
Justice Mayor,
answer that. You don't answer that. Thank you, Mr. Campbell. Thank you, DCJ.
Thank you.
Thank you, Mr. Campbell. You hinted at the beginning this would be the. I'm here.
Sorry,
You hinted at the beginning that this was going to be the match of the day, correct? Anyway.
That was my tongue.
It's perhaps the last match of the day. You will accept that the cases tell us that we don't have to look at pleadings with the sort of granularity in looking at every possible detail. It also tells us that we're supposed to interpret them generously and not highlight any flaw or imperfection. I mean, that's generally the approach. Now, that being said, the case that's being advanced, really, and mindful of what our courts have said about the nature of cartel activity, the nature of collusion, is that here's a conspiracy. It says it starts in 2007, but it continues until at least September 2013, not so.
Yes.
That's explanatory. That doesn't say it ended in 2013, but at least it continued until that point to our knowledge. But we're not saying it ended then, but we're able to say that to our knowledge, it ran for those years. And then it goes on to say, well, we can't say if it's ended or it continues, right? That's consistent with the first proposition, because they didn't say it ended in 2013.
Well, you
said at least, if it continued, to our knowledge, it continued until at least. And those words at least are used advisedly. It doesn't say definitively it ended in 2013. It continued from that date until at least. And that's the first possible date when it could have ended. And then it may have continued under different guises and different forms. What I'm asking you is that, what is so vague and embarrassing about that? Or are we really looking for imperfections and flaws? When one looks at it in its totality, doesn't it provide a sufficient basis? That's all.
Justice Colopin, before, or maybe slightly after, the paragraph that you refer to, saying to at least September 2013, the Commission pleaded that they had no knowledge of the end date. Now, if somebody can explain to me why those two comments are consistent and not contradictory, well, I'd withdraw the exception.
Okay.
They're not.
Well,
They're
let's
completely
see if we can, and maybe then I can hold you to undertaking. If someone says it continued at least until then, right? So,
But if they don't know, if they say that they don't know when it ended, how can they say it continued until at least?
what's inconsistent about that? Because if I'm aware of a conspiracy, and I have information that at least objectively shows this conspiracy ran between this period, right? Then I'm entitled to say, to my knowledge, it ran from this point at least until that point. I can't say beyond that if it continued to run. I don't know if those conspirators are still in the business. I don't know if they passed on. So there's nothing inconsistent with that. So will you withdraw the exception?
No, certainly not, because it is inconsistent.
I thought you wouldn't.
Because
Yeah,
you can't both not know something and know it.
Okay. Thank you, Mr. Wilson.
Thank you, Mr. Campbell. That seems to be it. Mr. Ngogaitobi.
Thank you, Deputy Chief Justice. Could I start with the question of appealability? So the first objection we take is that this is not appealable. We rely on the judgment of this court in Pretorius versus Transport Pension Fund, in particular in paragraph 21. So that's in 2019, volume 2 SA, page 37, paragraph 21. But this is all common ground. Dismissal of an exception is not appealable. Why? Because it's not dispositive. Unlike upholding an exception on the basis that the claim is bad in law, because then the claim is dismissed. Now, of course, in this court, the standard is interest of justice. So even if something is not dispositive, interest of justice may require that it be entertained. But there's nothing in the interest of justice that requires this court to entertain this appeal at all. The claim that the pleading is unclear is a baseless claim, because there are three submissions made, but the second and the third are tied to the first. And the first is this conduct continued at least. In other words, the minimum we know is September 2013. The maximum we don't know. So that's so clear, and there's nothing contradictory there, which is why the pleading thereafter says the conduct would have continued beyond the minimum period that we have to a maximum period that is never, unknown. Now, for vague and embarrassing, there is an additional requirement of prejudice. So because a vague and embarrassing, it's not a failure to disclose an action. Are they embarrassed? The embarrassing part is embarrassed in the sense that you are prejudiced because you cannot answer. That's what the embarrassing is. So are they embarrassed by that? They're not embarrassed by that. Because if their point is, for us as BNP, it ended with the departure of cuts, they can plead that. And what we don't know is the balance beyond the at least part. And if they have no knowledge, they can say we have no knowledge. So they are not embarrassed in pleading on that score either. So there is no contradiction. This horse has been beaten so many times, but it has no legs. That's the end of it. But there is a third point here, which is when it comes to the question of the cessation, the law established by the Competition Appeal Court in the case of power construction versus the Competition Commission 2017, Volume 2, CPLR 589, based on judgments like Paramount Mills and Videx Wire Products, really says this: what is a date of cessation of the conduct? The date of cessation of the conduct is the date by which the benefits of the cartel conduct stop flowing to the beneficiaries. And it's so clear when they say paragraph 43 of the judgment, they say, the prohibited conduct does not end or cease with the conclusion of the agreement fixing the selling price. It continues to exist, and its effect continues to be felt when the future prices agreed upon pursuant thereto are implemented. So one is no longer now focused on the actual deal between the colluders, but is looking at the wider market impact. So when that market impact stops, that's when the conduct stops. And then the same approach is taken in Videx Wire Products, cited in paragraph 44 of the judgment in power construction. This is what is said in paragraph 44. It says, a prohibited practice is generally constituted by initiating conduct, followed by the anti-competitive effects intended by the colluding parties. Section 67(1) envisages that a prohibited act will be one which continues over a period of time and is thus capable of ceasing. The prohibited act is thus not constituted only by the initiating conduct, but also within appropriate bounds by its intended ongoing effects. To take a simple example, if two firms collude with each other to fix prices, and if each of them then concludes a 3-year supply agreement with separate customers at the fixed prices, the prohibited price fixing is constituted by the initiating act, that's the deal with the colluder, and by the conclusion and performance of the resultant contracts with the customers. So it is a wide thing to talk about a collusion. But for our purposes, the only people who know when the benefits stop flowing are the parties to the collusion. So they are the best person to tell us when did the conduct cease. Because at this point in time, the Commission's information only knows the departure of cards, but the departure of cards is not in law the cessation date. And then finally, this point has been debated in full before the Competition Appeal Court. It is one of the few instances where the Competition Appeal Court is completely correct. Because what it says is that in order for you to draw us into this debate, you must show us how you are prejudiced. And then it says you cannot show us how you are prejudiced. And for that reason, I'm dismissing your appeal. So that's, in fact, a commendable approach to take. So we would therefore submit that this is a hopeless appeal. It should be dismissed. Thank you, Deputy Chief Justice.
Thank you very much, Advocate Ngoitobi. Any questions? Go on.
I take it here as well, the Commission doesn't raise any challenges to jurisdiction.
We should have, I think this case is different to every other case. We should have actually argued that it does not engage the jurisdiction of this court. But I looked at our answering affidavit, we expressly concede that it's within the jurisdiction.
Thank you, Mr. Ngoitobi.
Well, that seems to be it.
Thank you, Deputy
Thank
Chief
you,
Justice.
Advocate Ngoitobi. Advocate Campbell.
Thank you, Deputy Chief Justice. Just two very short points. One is my learned friend addressed you on the proposition that the only people who know the full length of a cartel are the colluding parties themselves. That is so initially. But remember that they have one leniency applicant and they have 4 or 5 settlements. So in fact, 5 of those colluding parties are now in touch with them and have settled with them. So, of course, the knowledge of the colluding parties is now the knowledge of the Commission, so they can't pretend that there's any distinction between the two in that respect. Finally, on the question of prejudice, it seems to me to be extremely obvious if I admit in one part of the referral that the Competition Commission has no knowledge of when the practice ended. What do I do when I get to the allegation that it ended in September 2013? I haven't got the slightest idea. But I'm going to find myself, I'm quite sure of it, pleading inconsistently. There it is. Thank you, Deputy Chief Justice.
Mr. Campbell, what's the constitutional issue in this matter?
Principle of a fair trial and rule of law, because the Competition Appeal Court required them to plead an end date.
That means every exception would entertain this court's jurisdiction.
Well, this one does. I haven't given, I don't know what others look like.
Yes, if that's the argument taken to its logical conclusion, then every exception would fall within this court's jurisdiction.
Well, if there is a prior court order by a competent court saying you need to plead the following elements, then you would always have a rule of law on a constitutional issue.
Yes, thank you, Mr. Campbell.
Yours is a proper exception. I suppose if we do uphold it, what must happen is what normally happens is they must fix the problem.
Fix it, yeah.
Now, you don't have to answer this. This is a rhetorical question. If everybody had raised the proper exception, excluding the other things, that's probably, we probably wouldn't be here. But anyway, thank you.
Well, I think we've come to the end of this case. We'll reserve our judgment. Thank you very much to all the council, your written submissions, your oral submissions. Thank you very much. Could we have the responses to the Commission's list of errors of law by Monday? No, but why Monday? Because they only had a day. So could we have it tomorrow, please? I'm sure that's fair. Thank you very much. Court adjourns.